support, opportunity, unity, legal relationships, the sole Amendment Act of 2025, and applauds Chairperson Parker for advancing this legislation crafted for and by young people. While we support the goals of B 260401, the Youth Records Transparency and Oversight Amendment Act of 2025, and B 260400, the Statutory Neglect Amendment Act of 2025, we have identified several provisions that could be further clarified and enhanced in these bills. As the Deputy Attorney General for FSD, I oversee attorneys that represent the district in cases of child abuse and neglect, working to ensure the safety and well-being of the district's children. The bills before the committees today cover both the abuse and neglect system and the juvenile delinquency system. And while FSD handles abuse and neglect cases, our Public Safety Division oversees juvenile matters. However, I will be testifying to both. OAG strongly supports SOUL. We again thank Chairperson Parker for introducing this legislation, and we urge Council to advance this legislation with two recommendations that we believe more closely align the text with the intent of the young people who developed the proposal. Retain the term sole family and eliminate the term incumbent rights holder. Today, 50 to 60% of older youth in foster care age out of the system instead of exiting to a stable and permanent home. Youth aging out of care lack the familial and social supports necessary to navigate transitioning to adulthood. Thank you. Putting them at risk of joblessness, housing instability, and other difficulties. Stability in adolescence is a critical component that leads to stability in adulthood. The system current options are not working, and we need SOUL and an alternative path for young people aging out of care. For B 26400, OAG appreciates Chairperson Parker's effort to update the district's definitions of neglect and to clarify that conditions of poverty alone do not constitute neglect. Families must not be separated solely because of economic status. I first want to clarify current practice around this issue. We are already required to demonstrate that the neglect is not solely due to not solely due to the parent's lack of financial means. But the bill proposes, and we support, strengthening that financial means test. If the bill passes, we will have to show more than a parent's eligibility for or receipt of public benefits in order to establish that neglect is not solely due to a lack of financial means. This increases our burden, and we support it. When poverty is conflated with neglect, there's a greater risk of unnecessary and traumatic family separations, increased systemic and racial bias, and hindrance to effective intervention. The proposed language contained in our written testimony reinforces this principle and ensures that families receiving public benefits are not unfairly stigmatized or subjected to unnecessary child welfare investigations. We urge the Council to adopt the language that explicitly affirms that poverty is not neglect. We also recommend removing the clause demonstrated by reasonable efforts by the Child and Family Services Agency pursuant to Section 4-1301-09A from the proposed definition of neglect under 162301-9A2. Under current DC law, CFSA is required to make reasonable efforts to prevent or eliminate the need for removal of a child unless doing so would place the child at risk of harm, and to preserve and reunify families. CFSA's current obligation applies regardless of the type of abuse or neglect alleged and is separate from the determination of whether a child has been neglected. Incorporating the reasonable efforts requirement into the definition of neglect blurs the line between the neglect determination and the removal decision, and this conflation risks confusing the legal standards and could improperly shift the focus of the court's inquiry. Next, we recommend reinstating a revised version of Section 162301-9A3 into the statutory definitions. While OAG agrees that the condition of the child is the appropriate focus in determining whether government intervention is warranted, we also recognize that there are instances where the parent's substance use or mental health may have a direct and adverse impact on the child's well-being. In such cases, it is essential that the law provide a clear basis for intervention when there is a demonstrable nexus between the parent's condition and harm or risk of harm to the child. We propose edits in our written testimony that maintain the appropriate focus of the child's condition while ensuring the law remains responsive to serious and foreseeable risks. It also affirms the government intervention must be grounded in evidence of harm or risk of harm, not merely in a parent's diagnosis or behavior. Next, we recommend striking section 16230123A4, which lists exposure to domestic violence as one instance in which a child could be considered abused. Eliminating this provision would not impact OAG's ability to prosecute these cases, but it would allow for us to continue to be thoughtful when one parent is a victim or survivor of domestic violence themselves. We have 3 additional proposed amendments to reflect current practice, and these are included in our written submission. But I want to take a moment to touch on some of the information shared by the previous panel. Abandonment is currently defined in multiple parts of our code. It's defined as 10 days if a child is left at a hospital and 4 months in other circumstances. The current proposal simplifies that definition and combines both timeframes into one definition, which we strongly support. For B26401, we agree that council may need to access additional information than that which is publicly available to legislate effectively and conduct robust oversight. The district's juvenile confidentiality laws are stringent, recognizing the critical need to safeguard the sensitive information of vulnerable underage youth and their families. Further, these juvenile confidentiality protections cover both delinquency and neglect proceedings, so any change would affect access to both delinquency and neglect case records. We have concerns that the legislation as drafted is overly broad and that it grants full access to juvenile case records and the social files. We look forward to partnering with council to strike the right balance between safeguarding sensitive information and ensuring that our legislative body can nimbly respond as issues arise, develop legislation based on data, and provide oversight of agencies. In addition, as both committees consider amending the juvenile confidentiality provisions, OAG has a technical amendment that we would like to include during markup, and we'll share this language after the hearing. Finally, OAG supports B26407, especially its efforts to promote transparency and address overcrowding at the Youth Services Center. We're concerned about the definition of recidivism, primarily that OAG should not be the sole source to supply the data, and that the language used is broad and not reflective of common measures such as arrest or papering. These concerns are laid out in detail in our written testimony, and we look forward to working with the committees to draft a definition that addresses these issues. In sum, we are grateful to both committees to testify on these important issues. We look forward to partnering to advance legislative changes that benefit all district residents, and we're available to answer any questions.
Thank you for your testimony.
Ms. Petrino's testimony covers both of ours, so I'm here to do Q&A.
Oh, brilliant.
We
brilliant.
split the bills up.
Brilliant, brilliant. No, thank you. There's so much to cover. Let's start with statutory neglect. There's a part of the bill that would subject parents to a neglect finding if there is a finding of domestic violence, if the parents are not trying to rectify the situation. It sounds like through your testimony you're taking issue with that. Can you elaborate?
Yes. So currently, that's the current standard. So we are able to prosecute cases alleging that a child has actually been abused if they've been exposed to domestic violence, and neither parent has taken reasonable efforts to prevent that infliction of harm. It's actually considered a mental injury under the current law. We, at one point, supported the idea of codifying that case law, making it clearer to parents that this is considered abuse and putting it in the statute. In doing some further research, discussing with our partners in the community, different advocates, we understand now that including that language in the code, while the intention of that we believe is appropriate, would actually be setting us backwards on that issue. So taking it out of the code doesn't mean that we could no longer prosecute it and keep those kids safe, but it does mean that we would have more discretion to consider the circumstances of the domestic violence. Is one of the parents the survivor or the victim of the domestic violence? And are there ways we can be thoughtful about handling those cases that also are informed of how the parent is the victim themselves?
And when I hear discretion, I hear we get to determine, in some instances, a parent is the victim of domestic violence and is not trying to resolve the exposure of the child or the young person to said violence, and still leave that young person with that family. That's what I hear when I hear discretion, that you may choose at times that this doesn't warrant removing the kid from that environment. Is that fair?
I understand that it could be interpreted that way. I think it is perhaps a fair interpretation, but a bit more complex. Any definition of abuse or neglect that we currently have doesn't necessarily. Oh, I'm sorry. Sorry.
No,
Not big enough for this chair. Our current definitions of neglect, just because a parent is found to have neglected their child, just because they're substantiated for neglect, doesn't mean that their child is necessarily going to be removed. So regardless of the definition of neglect, just because you're found to have been neglectful doesn't guarantee that the child has been removed. That is a separate inquiry or separate part of the process.
Yes.
And not all substantiations come to the Office of the Attorney General. Not everything is court involved. I think what putting this language in the statute in terms of the domestic violence does is sort of create a bright line for instances of domestic violence. It makes it very explicit that exposure to domestic violence alone is abuse or neglect, and doesn't give us the ability to assess what protective capacities that survivor parent has. Maybe we're not wanting to remove because the victim parent has moved to a new home and no longer lives with the abusive parent. Maybe the protective parent has put their own protections in place. If they share a child in common, maybe they've worked out a schedule so that that parent can see the child that doesn't involve the victim parent having to be present for those interactions. There are other safety precautions that victim parents can put in place to protect themselves and their children, and we just want to ensure the law honors that.
Okay, just for clarification, what I'm hearing you say is the current practice is what we're codifying. It's not that a young person only being exposed to domestic violence would warrant a neglect finding, but that the parent is also not trying to rectify the situation. So it's two parts. You're exposed and the parent is not trying to get away or solve the problem. I also hear and take to heart what you're saying. The rigidity of having it in the code limits, I guess, or ties the hand of the Office of the Attorney General potentially during these proceedings. I will commit to looking at that with Councilmember Pinto. It does give me pause, though, because, well, again, what I'm hearing is, well, there's sometimes we may want to leave the kid in that environment, and I think that's harmful. I do want to move on.
Can I just say one more thing?
Yes.
I would like to perhaps reframe your perspective that it's not leaving the child in that home. It might be leaving that child with the victim parent who can protect the child, rather than taking them from their victim parent, the survivor parent, and placing them with strangers.
Yes. We don't want to separate kids from their families.
Right.
What I'm arguing is that what the bill says is that if the victim parent is exposing, willingly or unwillingly, a child to domestic violence and not trying to rectify the situation, in other words, I am the victim of domestic violence, my child sees this day in and day out, and I'm not taking steps to seek safety for my kid, that is what the bill is saying. It is not just simply saying you're the victim of domestic violence and now you lose your kid.
So to that extent, I think the bill could be clearer, and I think the advocates from Children's Law Center will probably explain or suggest some explicit language that could be put back into the bill to make that piece clearer.
Understood. Okay. It is my understanding that the Office of the Attorney General does not support the carve-out for cannabis in the existing neglect code.
The Office of the Attorney General's current position is to maintain the status quo as your bill has drafted.
Yep. And can you just elaborate on what is the status quo? And I'm happy to talk more about what some advocates would want us to change the code to as it relates to cannabis use.
Sure. So the current status quo is that hospitals are supposed to call when a child tests positive for any illicit substance at birth. We know that not every hospital calls, and not every hospital calls every time or tests every child that's born in the District of Columbia. And to that extent, we would like to work with your office on trying to resolve that if there is some way to increase those protections and limit those disparities. Taking it one step further, a positive tox, is how we refer to it, is not enough alone to be substantiated for neglect. There must be something more than that. And that language specifying that is in a different part of the code. So for example, our office, OAG, could not petition a neglect case based solely on the fact that a child tested positive for something at birth. It would have to be more than that. It would have to be, and the parent has ongoing substance use issues that adversely impact their ability to care for the child or other things.
And what advocates wanted or petitioned the committee to do was to essentially carve out cannabis use, to say if a mom and a child test positive for cannabis, that cannot be inclusive of any neglect findings. As we did our research, the research is mixed and inconclusive at best.
Right.
What I was wanting to know is that actually harmful for the kid? And there's some research that says, yes, cannabis use by a mom during pregnancy is harmful. There's other research that says it's not. And so the reason why the committee opted not to make any changes there is because the research just doesn't support it.
Right, we support that.
Yep, okay. I'm running out of time. Still on the neglect statute, how will the proposed updates in the bill, notwithstanding the list of changes you have, impact OAG's work in the neglect space?
I think ultimately what the changes in the bill will do is make our practice clearer. We appreciate the confusion around the definition of abandonment, the fact that you have to look in 23019A and then also in 162316 to determine what is abandonment causes unnecessary confusion. And we think bringing all of that into the definitions of neglect and splitting abandonment from abuse will be helpful. We believe that the most important thing, I think, about the bill is the explicit language regarding poverty not equating neglect. We've heard the advocacy community on that. We already incorporate it into our practice, as does CFSA, but we think it's important to be explicit about that so that it can be ensured that that practice continues regardless of who is in our seats in the future.
Yep, and I do support the inclusion of the affirmative inclusion of poverty is not neglect, and we'll take that into consideration.
Thank you.
Before I move to any other bills that you testified on, I'm going to turn to my colleague for a round of questions, and then I'll come back. So with that, Councilmember Pinto.
Great, thank you. Thank you both for being here. So nice to see you. So I want to pick up there around the neglect definitions, because I appreciate your clarification that just because someone has been designated as, or neglect being determined doesn't necessarily mean it's going to enter the court process. And so as you think about the current gaps in the law for neglect, where would you like to see those gaps filled?
Specifically pertaining to the definitions?
Yes, of neglect.
Yes, I again would reiterate the importance of clarifying different provisions. Splitting abuse from abandonment, I think, is important. I also think what the bill proposes regarding explaining some examples of what constitutes physical abuse is important. Our current statute doesn't do that. Right now, it explains what is not discipline. I know there was testimony earlier about the physical discipline or the physical violence of children under the age of 3. And I just want to note that currently physical discipline is prohibited for children under the age of 18 months. So this bill did increase that age, which we support. I also think it's important that we codify some of our case law. The provision 1623.019A2, which is sort of what we refer to as general neglect, requires a risk of harm requires harm itself or substantial risk of harm. And so I appreciate the bill adding that language to the law itself, making it clearer. I know that the current bill takes out what is the current 3, the mental and physical incapacity, and we're asking to put that back in, but the language we provided updates it to include that same explicit language about the harm or substantial risk of harm, because we do think it's important to focus on the condition of the child and not just the status of the parent, because the condition of the child is what brings the case to court. Our court is very remedial. It's not meant to be punitive to the parents. And so maintaining that focus is important. And one thing I'll add is that we worked very closely with the Children's Law Center, but we also worked very closely with parents' attorneys, the attorneys who actually represent parents in our neglect proceedings when discussing these changes. And they pointed out the difficulty that they sometimes have in explaining what the law is to their clients who are being accused of these things. And we do think that Councilmember Parker's proposal does make the law much clearer and will be beneficial to the parents as well.
Okay. What is the mission of the Family Services Division?
Oh, that is a great question.
Thank you.
I could talk about it for longer than 7 minutes and 12 seconds. The mission of the Family Services Division is to represent the district and CFSA largely in abuse or neglect cases, and really to help children and families in the District of Columbia to ameliorate the conditions of neglect that bring families and children across our desk. The neglect world is a special one. There's not a lot of us in this division. It's quite confidential, as we've seen from the records bill. And our division works very closely, again, with the Children's Law Center, with our opposing counsel, to ensure that we are handling these cases in a way that addresses the needs of the child and ensures the child's safety, but also is very cognizant of the circumstances of the parents who are involved in our cases. Some of the things that Ms. Riley spoke to earlier, we're very mindful of and try to ensure in our practice that we're eliminating bias and we're treating everyone fairly under the law, and working to keep kids in their homes, or if they have to come out of their homes, to get them back in their homes. And then, of course, if unfortunately they're not able to go back, we continue to work until they have a permanent home. I think that's one of the unique things about our division. Our job doesn't end once a parent is found to have been neglectful or a child is found to have been neglected. We, at the Office of the Attorney General, stay on those cases, and we work for the next year or 2 to get that child home or in another permanent arrangement.
Okay, so that is a big mission.
It is.
And how do you advise the attorneys in this division about how to weigh the immediate safety concerns of a child versus all of that around the amelioration mission to address the underlying challenges?
Sure. So a lot of that work is done very closely with our client agency. We are co-located in the same building. We spend a lot of time on co-training, learning the clinical side of things, so we are not the clinicians ourselves. We have honest conversations about the work that the agency did or didn't do prior to a child coming into foster care. And we have honest conversations about what we should expect of parents going forward in order to have their children's returned home. I think it's very important to keep the standard that we aren't looking for perfection. There are no perfect parents, right? We're looking for parents who can keep their kids safe and have appropriate parenting techniques. And it's the government's responsibility to help them, achieve those goals if they aren't able to do it on themselves. And we spend a lot of time in court talking about what the agency has or hasn't done, and whether the child is safe and what safety risks still remain if we are considering sending the child back home.
Okay, when you say it's the government's responsibility, it's always of interest to me to figure out kind of who plays what role in which lane. Mm-hmm. And so as the prosecutor's office, like, where does that role come in versus the responsibility of CFSA versus a court versus what we are not just asking of our parents, but expecting and really demanding of our parents in order to advance their children's safety?
Mm-hmm. I would say that sometimes the lines are a little bit blurred, but generally speaking, it's the agency's responsibility to assess a parent, assess what their needs are in order to keep their child safe, assess what services are available to them, work with them on obtaining those services. Then it's the parent's responsibility to engage in those services, to learn from them and demonstrate changed behaviors. It's our responsibility as the Office of the Attorney General to ensure that CFSA is providing those services. By providing, I mean identifying and referring the parent. If it's not a service, the agency provides itself. And, we have court hearings. We're supposed to have them every 6 months. Most judges bring us back in every 3 or 4 months. And at every single one of those hearings, we're outlining in a court report that the social worker previously filed what the agency did in the last 3 months to help this parent reunify. We're outlining what the parent has or hasn't done in terms of progress towards those goals. And then the court and the guardians ad litem, the parents' attorneys are holding the entire government accountable in those hearings and arguing whether we have or haven't whether the agency has or hasn't done that due diligence of reasonable efforts to reunify. Reasonable efforts is a term of art in our world, and it's one that is considered at every stage of the process.
Okay, thank you very much for that. And I want to follow up with you around truancy from our last conversation with the last panel. How many truancy cases have you prosecuted in the last year?
In terms of the data that the Office of the Attorney General keeps, it's hard in the neglect system because there's up to 11 allegations of neglect that we can petition in any one case. And so often we petition multiple allegations. I do believe in CFSA's oversight data that they provided back in February, it will say how many calls they get for educational neglect. We are trying to drill down in a more comprehensive way how many cases we see exclusive to educational neglect to help inform counsel in that regard. Often when we see educational neglect, it's coupled with another behavior issue of the parent, whether it's mental health, substance abuse, etc. And so it's difficult to separate those two out.
Okay, understand. But from a prosecutorial perspective, how many educational neglect cases have you all brought?
I cannot give you that data right now. We can try and see. I believe I'm going to defer to Ms. Petrino because she has some numbers with her.
Okay.
Yes, so educational neglect, the way it's currently defined in the code, is part of that general neglect provision. It's 162301(9)(a)(2). So I can tell you that an overwhelming majority of our cases involve that allegation, which includes the lack of education or subsistence or control. So it's the general neglect provision. We can work to drill down on those numbers and determine what is exactly educational neglect versus the other forms that fall under that number.
Okay, thank you. I would be very interested in that number, not just in the allegations that have been brought, but in the actual cases you all have brought.
Yes, that would be the number we can provide.
Yeah, okay, thank you. I want to talk a little, kind of out of time. This time really ticks down. Okay, thank you both.
I want to pick up there on educational neglect. I'm glad you're picking up on this. I think the answer is there haven't been any findings of educational neglect. And I think for context, it's important to remind folks last year, I believe, or maybe it's 2 years ago at this point, I introduced a bill that tried to define what educational neglect was. And I thought it was pretty lax. It essentially said 30 missed days of school that are unexcused, where the parent is not trying to rectify the situation and get the kid in school, constitutes educational neglect, and all hell broke loose. Advocates, I think the OAG opposed it, CFSA opposed it. And I am still struggling with the fact that we say we have a truancy problem, we invest so much money in our schools, yet everyone's very squishy about holding parents accountable to ensuring their kids show up to school. I'm just going to say that for the record. Feel free to weigh in. We're old friends and we go back and forth.
Of course.
But yeah, your thoughts.
We've talked about this on more than one occasion and definitely could continue to talk about it. A couple clarifying points I would like to make. First is the standard which CFSA uses at the hotline to determine whether they will screen in or screen out. I will let the agency speak to that. What you are asking is what is...
And if I could just interject,
Of course.
for those that are watching, that, and I'm not sure where the feedback is coming, if you could just...
Oh, I'm sorry.
CFSA receives calls for young people under the age of 13. I wasn't going to even go here, but since we're going here, they receive calls for educational neglect referrals, namely from our schools, for young people under the age of 13. They screen in or screen out. To screen in means they are going to investigate the family. What we know is that the vast majority, I want to say over 7,000 referrals have come in over the last year or to date, and I think 98% of those calls have been screened out because CFSA would argue that it doesn't rise to the statutory definition of educational neglect, which we don't quite have. Okay, keep going.
Excellent. And so you have that pool to begin with, which then CFSA makes its own determination. So then you have a smaller pool that then comes to the Office of the Attorney General. We do file petitions on educational neglect and do have adjudications in the family court based on educational neglect. Those are the numbers. I think if we quoted you a number, it would be that all-encompassing subsection 2. What we're going to try to do is drill down exactly of the subsection 2, how many were on educational neglect. And the only other quick thing I'll add is it was 3 years ago, I believe, the council very generously granted our request to add another section to the Family Services Division, which is CPS 5, which is actually working more in the in-home population. And one of the things they are focused on is getting the cases of educational neglect brought to our attention sooner in the process, because we want to be able to do that intervention at the court level if we need to.
Would you agree that educational neglect is not clearly defined in our code?
I would agree that a per se definition of any definition of neglect could actually cause more harm.
That was such a lawyer's
lawyer
yes,
answer.
that was such a lawyer answer. Okay, let me get back to my line of questioning. Let's go to the SOUL Act.
Yes, please.
One of the points of feedback provided is that you want us to refer back to the SOUL family.
We do.
So for context, this legislation was crafted by and with foster youth. And the SOUL Act made reference repeatedly to the SOUL family. And I'm fine with that. But there was ambiguity about what SOUL family actually meant. The committee's attempt to change the language was to provide a level of clarity that we're actually talking about the support family structure. I hear the testimony loud and clear, and I have a feeling we're going to hear this testimony a lot today, so I get it. What I wanted to ask about was the second critique provided, that originally the language in the bill spoke to birth parents and the rights of birth parents, and it was changed to incumbent rights holder in an effort to be more inclusive because not all birth parents have family obligations. Maybe it's a grandmother, maybe it's another family member that's not quite the birth parent, and that's what we were trying to get at. Can you speak to why you're advocating that it go back to the term birth parent?
Absolutely, and we'll acknowledge that this is a very difficult part of the SOUL legislation to really narrow down to what is the most appropriate way to handle it in the law. For example, we took a lot of information from Kansas and what they struggled with, and we thought it was best in the district, and I'm sure you'll hear this from our colleagues at the Children's Law Center who co-led the legislation work group, that we wanted to look at what was already in the statute here in the district. And so we relied a lot on how legal guardianship is already handled. And so we started with that sort of as our central point, and that differentiates, as does legal custody, the rights that stay with the birth parent and the rights that go to the third party, whomever that may be. In the SOUL legislation, because we're putting it at age 16 is the earliest age one can exit care to SOL. You have that population from 16 to 18 that you need to be very specific and very clear about, since the youth is still a minor. And so that's where you really have to designate what does the birth parent retain, similar to in legal guardianship, and what goes to all the people in the SOL family. And in that category, you have someone who's providing housing. Okay, well, they might have more rights or need more rights. Then you have someone who's going to handle education, someone who might handle medical. And we just felt that introducing a whole new term that we don't already use in our system would actually confuse instead of clarify. And so our intent, and happy to work with the committee on what the best language is just to really differentiate who in the group gets what right, particularly for the 16 to 18 population.
I'm persuaded by that.
Thank you.
I thought that was really,
Thank you.
you won me over. So I'm happy to
Excellent.
make that change.
I did my job today.
Yes, yes. Outside of those two areas with the SOL Act, are there any other concerns that the Office of the Attorney General has with the legislation?
My understanding, I think, is with Children's Law Center, we have provided some additional red line edits, but overall, I think as it's written really gets to the heart of what we're trying to achieve, and really hope that Council will be able to pass this as expeditiously as possible. You're going to be very moved when you hear the testimony of the lived experts.
Yes.
And so really proud to support them in that endeavor.
Love it, love it. Thank you. I wanted to move to the Youth Records Transparency Act. For context, there have been instances, high-profile cases that many people probably know about, where I've gone to MPD to say, what is going on with this case involving this young person? MPD will say, we can't tell you. We can't tell you any more than what the media is already reporting. Go ask OAG. Then I come to OAG, and what the issue is our very strict juvenile or access to juvenile records. Just for the record again, and I know you spoke to this, but would you agree that the committee should have access to juvenile records as it relates to our juvenile delinquency system?
We definitely agree that the committee in some capacity needs access to information. We completely acknowledge the place that it puts you in without being able to do your job because you don't have access to that. We are just inherently cautious about who gets access to the information. As Ms. Petrino outlined in our opening statement, you could start in the neglect system. That social file follows you into the juvenile delinquency system. The neglect system could be about me and my 5 siblings, and you want information in the delinquency system just about one person. So I think with the right guardrails in place, we absolutely can reach an agreement on the council getting access.
And can you distinguish the social file
Sure.
from one's criminal record file, if
Sure.
that makes sense?
Absolutely. So Title 16 talks about law enforcement records, it talks about the legal file, and it talks about the social file. There's also going to be reference to CFSA's file, which is codified in Title 4. So there's a lot of different places and different components of what could actually end up in a child's record. For example, in the legal record, you're going to get the neglect petition, the delinquency petition, motions, pleadings, court orders. In the social file, you're going to get evaluations from DBH, GCPS, from the agency if they've done their own assessment, both DYRS and CFSA. So a lot of the clinical social information is in the social file. The court proceedings are in the legal file. Both of those are spoken to in Title 16.
And when you say some guardrails, you would support the committee having access. Do you want to speak to what those guardrails should be now, or?
I think if we could have a conversation after the hearing about that, absolutely. But I think fundamentally know that you need to have access in some shape or fashion.
Got it. And for the record, I don't need a young person's entire file.
Right.
That is not the goal. but it is important for the committee to do oversight. And
Absolutely.
and this has been a barrier, and we heard from also the Ombudsman for Children that it's been a barrier for them as well.
Right, and if I could say two quick things on that. One, for the ombuds, definitely agree in their ability to identify crossover youth that they need access. They currently have access to CFSA information, but they don't have access on the juvenile side. And second, we alluded to this in our written testimony, but even within the Office of the Attorney General, we have challenges with the confidentiality. For example, the code speaks to those assigned to the Family Division, which is Family Services, Public Safety, Child Support. But when our Civil Litigation Division goes to defend the district, they're not considered an assistant within the Family Division. And so we're also going to ask for a modification to the code to allow our Civil Litigation Division to have access to do their job as well.
Okay, I'm going to stop there for time. I'm going to turn it to Councilmember Pinto for another round of questions.
Great, thank you. I just want to raise the survivor parent issue because we've talked to several advocates who've raised concerns around the definition of neglected child, that there's no provision specifying that a failure to seek a civil protection order is not dispositive of a failure to protect a child from abuse. And as we've seen, in certain cases, that seeking a CPO can directly incite violence against survivors by the abusers. And so I understand that concern of not wanting that to be dispositive. So I just wanted to re-raise that if you have any thoughts on those particular cases.
Yes. So currently, the way the definition of abuse is defined, it includes that language, which intended to provide just one example of how a parent can make reasonable efforts in that way, and obtaining a civil protection order being one of them. What we have found is that it has sort of been misinterpreted in that the expectation is that that survivor parent will go or is required to go get a civil protection order in order for CFSA to not substantiate them or for their child to not be removed. And that was certainly, we don't believe, the original intent of that. So I think the bill takes that language out entirely. So I think that taking it out entirely gets at the same, has the same effect as putting that language back in, but certainly wouldn't oppose that language going back in. And in fact, I think if council is to leave the exposure to domestic violence in the definition of abuse, then I do think in that instance that language must come back in, or it's going to be sort of a per se definition that just because you're exposed, you are therefore neglected, regardless of what, if anything, was done to protect that child.
Okay. Thank you very much for that. Moving to the transparency and privacy issues, just at a high level, can you explain kind of where OAG's position is around youth privacy to protect the young person versus what I hope you can understand our interest is in understanding the data so that we can drive forward policy that's going to be most impactful?
Absolutely, and I think that's a great way to frame it, is there's the individual person's history, record, information versus how that factors into a larger data portfolio. And I think the larger data portfolio is where we get, obviously through the Criminal Justice Coordinating Council, which we're a part of, is how we can look at the system and say, are we doing the right thing? Are we putting our resources in the right place? Are our laws legislating what we need to legislate to keep the community safe? And so from informing overall data, absolutely, that is crucial for all of our agencies and all of our entities for oversight capacity. I think the nervousness we have is with the individual's record being given to multiple people and the context not following it. I think if you looked, for us, even in our job, you were asking earlier about the Family Services Division, and we can read a court report and come to a whole conclusion of a family. Then I sit down and I talk to the social worker, and they add so much more of a perspective that's not captured in the written word. And I think we're just making sure that for the individual person's experience, nothing is taken out of context and nothing is given to anybody who should not have access. You, of course, need some form of access to do your job, and that's not something we have a problem with. I think it's that individual identifying information being put out into the general atmosphere that we have concerns with.
Yeah. I guess you can never really divorce the need to have more context from any data set, whether you're dealing with an adult population on any issue. And so, like, I appreciate that context is important for justice and to make sure that each case is handled with care. But from a data perspective, like, there's never going to be a perfect contextual environment to understand each piece of data.
Yeah.
Right?
And I would say the bigger issue I have seen in this current role with data is that we have so many agencies putting their data into one system, or hopefully into one system, that we are then being able to say, okay, this in the District of Columbia is where we fall on this issue or that issue. And I think the data validity, I am certainly not a data scientist and probably not the best person to speak to that methodology, but I do think that having access to that for overall data lessons is crucial to the work that we all do.
Okay. And you mentioned the CJCC and the work we do there, but I mean, to be honest, it has also been difficult getting data from OAG for that purpose, even in an extremely controlled environment with principals in the public safety ecosystem.
Yes, no, and I understand that. I think a couple things can go to that. I think first of all is where we fall in the system and what data is exclusively ours and what data is part of the court system, for example, or in relation to our data with the Metropolitan Police Department, for example. And I think the other thing that you might be speaking to kind of gets to our hesitancy and our skittishness is with not releasing individual records on 10 or fewer, or not, which I know in oversight has been discussed with the Attorney General. I think that we as a system need to continue to examine and evolve in terms of who needs access to what to make sure we're doing our job correctly.
Okay. And, I was moved listening to Chairman Parker talk about getting some information through the press as opposed to through our own work. And in the juvenile privacy space, I mean, there have been multiple instances where everyone in a particular community knows the young person we're talking about because the incident might have happened at school or down the street and everybody in the neighborhood saw it. And so we're continue to have these conversations about, like, no personal identifying information. And I totally understand, in order to protect the young person's future, we want to be really careful about that. At the same time, in practice, it's a little bit of an odd experience when, like, people in a particular community know what happened, saw what happened, but we can't get any information. I don't need the person's name or all those things, but there is an imbalance, I think.
Yeah, yes, and we were actually having this conversation with Councilmember Parker's staff yesterday about so you hear something in the ward that you serve or a constituent comes to you and you want to be able to know more about it. I think the two things are, how can we get you that information as quickly as possible and in a way that adheres to the confidentiality standards? And also, number two, obviously the restrictions it then puts on you as to who you can share that information with. And I think the intent of what we're hearing from both of your offices, and absolutely open to working with you on that, is you have to be responsive to the people that you serve, and that requires you to have access to information.
Okay, thank you. And I, appreciate that commitment. I will say I have been on the council for 5.5 years now, and we have been having this conversation with OAG for 5.5 years of this issue around privacy. And so it feels as though something new needs to happen in order to, I always appreciate the conversation and the partnership, but this issue has not advanced in a serious way in that time. And so that's, as we think about other legislative recourse, that's part of where we're coming from too.
Sure, and having only been in my current role officially since September, I can certainly take that on as a hallmark item.
Thank you very much. Thank you.
Absolutely.
Okay, a few more questions, and then we're going to turn to DRS. In your testimony, you argue that MPD and the courts, rather than solely OAG, should be responsible for providing juvenile data for tracking recidivism. Can you speak to your reasoning for that?
Sure. I think recidivism is another hard topic because I think it's, we've been asked by the CJCC to define it. I think we've shared our definition that we gave to CJCC with your office as well. I think I'll try to do this as succinctly as possible. MPD makes an arrest. They have an opportunity to divert at the time of the arrest and not even present it to the Office of the Attorney General. Then they can present a charge to the Office of the Attorney General, which we then have to analyze and determine if we have enough to move forward with the case or for social factors if we're going to divert. So that's putting us at step 2 in the process. Then if we do move forward with a court case, there's then the whole disposition that occurs in the court system. So I think the confusion with trying to determine an actual definition of recidivism is either looking at each individual agency or looking at the life of the system. If you look at the life of the system, we are not the exclusive agency in that spectrum.
Got it. And I remember when your office introduced the Road Act,
Yes.
this came up, and this was a point of tension where the OAG press release, I recall saying there is a 92% rate of recidivism, and then the director from DRS took issue with that, and the issue was that you all were defining it and looking at it very differently. What we're hoping to do is in statute define how we are looking at it. I hear your point, though, depending on what stage and or what purpose
Exactly.
You're using the data available might determine how you define recidivism.
Right, exactly. And I think we're all in agreement that we need one central definition of recidivism for all of the criminal justice partners that participate in the larger ecosystem for the district.
And for the record, what was that definition that you provided?
I think it is quite long. I'm not sure if you want me to read all of it
While you pull that up, I will say I remember Director Abed's definition that I was persuaded by, which essentially was that a juvenile in particular is accused of a new crime once out of detention, and I'm probably oversimplifying that, but essentially it was to not conflate charges or incidents that may happen while a young person is in detention, and I thought that was pretty reasonable. But what is the definition that you would recommend?
Yeah, and I think we haven't settled on a singular definition, but the other thing that I would add to what Director Abed said is also, if you want to analyze at what point the intervention occurred, like I was arrested on Monday and I was arrested on Wednesday. There probably wasn't an intervention between Monday and Wednesday. But if I was arrested on Monday and had a whole year of rehabilitation services, and then I was arrested a year later, wouldn't that be different analysis than me being arrested on Monday and Wednesday? I think it's the ability to have services, the engagement with the services, the impact of those services on the young person's conduct have to also be factored into our analysis of recidivism.
Okay, I think I was following.
Yeah. I think it's just not being arrested again and making a conclusion. It's also the looking at the services and the engagement with those services.
Okay, the subtext to this, and I'm wrapping up, the subtext to this is that our rates of recidivism for juveniles is way too high. And so I forget what the director's definition, I think, had recidivism at 50 or 52%. You all's definition had recidivism at 92%. What that is saying to me is even in the best case scenario, half of young people that are entering our juvenile detention system is coming right back. We have a revolving system, and I believe that's because we're not actually rehabilitating them. That's another conversation for another day. But I think that's important for us to name. Does OAG have the data necessary to fulfill DRS's mandated reports under this bill? So we are requiring DRS to publish data that the Office of the Independent Juvenile Facilities Oversight, I probably butchered that, used to report. As you know, that office sunsetted.
Yes.
Is there any information that you are working with DRS to publish and that you all have access to?
If I may get back to you on that, I was like phoning a friend while you asked that. I think I will need to get back to you on that.
Okay. I think I've exhausted all my questions. Councilmember Pinto, did you have any others?
I just have one more question. As we are in this moment in our city where we have federal forces and incursions here, and uptick in what we're seeing around immigration enforcement and the traumatization that that's causing to many of our families, what are you seeing in terms of family support or cases that OAG may be involved with or exposed to? And what efforts do you think we need to be doing more of in the city to protect our families?
I'm going to see if Ms. Petrino might have something to say about the neglect system. As I left that position a few months ago, I don't know if we've seen any instances of that specifically in FSD, impact to FSD cases.
I don't think we've seen much impact. I think that there was some impact regarding our unaccompanied refugee minor cases at one point, though I think we're addressing that, or it's picked back up again. But what I would say in terms of keeping families safe, I think the references to the warm line earlier and the whole point of putting in that poverty is not neglect is one way to keep families safe from unnecessary government intervention, encouraging families to take advantage of the community services that we have here in DC that they can learn about through things like the warm line or the family collaboratives. Minimizing that need for intervention unless there truly is a safety concern, I think, is one of the things that helps keep children and families safe in the current state.
Okay, and I guess as I continue to hear from families who might have fear about sending their children to school in this climate, are there other efforts underway from OAG or from CFSA to do outreach to those families to make sure that they have supports they need and that their children can continue to be educated?
I'm sure that there are. I'm not sure if Ms. Cullen might be able to speak to the public safety side.
And I think also on the CFSA side, it would be interesting when you have some of the advocates up later to ask them as well, because I know at the beginning of the school year, there was a lot of effort put into educating families about their rights and about sort of like secondary care plans that they should always have in place so that there is a family member or a loved one able to step in at any moment, regardless of the circumstances, to take care of a child, so the child doesn't have to come into foster care hypothetically because the parent was arrested or because the parent is no longer available. So I know there was a lot of effort with our community partners in the advocacy world to do that. I don't think on the public safety side we've seen, I will say on the juvenile side, that we've seen a direct correlation. The Attorney General is very keeping an eye on this, talking to our community engagement department, seeing what we can do in terms of making sure the community has the right information and the access to resources as a result of this issue.
And the last thing I would add is that I think that just underscores the importance of the work that CFSA already does in between the time that a referral is made and determining whether or not neglect exists, and then if it does, if a court case is necessary, allowing parents to articulate or make those plans for the child, for their child's care in instances in which immigration or incarceration could be an issue.
Okay, thank you.
Thank you both.
Thank you. I would just say poverty is not neglect. I fully agree with that. I'm going to use this as a public service announcement that if we take that adage to be true, which I believe it is, it also charges us to address poverty, which is on the rise in the district. And is especially on the rise for certain residents in the district, namely Black and brown residents. This council has advanced any number of measures to address poverty. Most recently, we passed and fully funded the child tax credit. It's worth noting that we passed it before, we funded it before, and unfortunately, the mayor cut it. And so while I appreciate the mayor's agencies and the Office of the Attorney General joining us and agreeing that poverty is not neglect, I hope you too will stand with us to champion the child tax credit and other measures to address poverty, but also call on the mayor to maintain its funding so that we can extend lifelines to residents across the district, namely Black and brown families. But thank you for your testimony. With that, we are going to turn to our friends at DRS. And Director Abed, I know you're on a time crunch, and thank you for being patient with us. If you could raise your right hand and repeat after me, or affirm that the testimony you're about to provide is the truth and only the truth. Okay, awesome. With that, you may provide your testimony.
Good morning, Chairperson. Shoot, it's still morning. Good. Good morning, Chairperson Parker and Chairperson Pinto, members of both committees, and all members of the public who are present and watching today. I'm Sam Abbott, Director of the Department of Youth Rehabilitation Services, and thank you for the opportunity to testify. I'm here to speak about proposed legislation that would have a significant impact on DYRS operations. Before I begin, I'd like to thank Mayor Bowser and Deputy Mayor Apia for their inspiring leadership. Mayor Bowser's unwavering focus on public safety reflects her commitment to supporting DYRS's mission, which pairs accountability with meaningful rehabilitation to help youth turn their lives around and become contributing members of society. I also extend my appreciation to the entire DYRS team. Their dedication and resilience are truly commendable, especially given the challenges that we face every day. DYRS shares the Council's commitment to improving outcomes for young people and to maintaining public confidence in our juvenile justice system. Several of these proposals would pose significant operational and fiscal challenges for DYRS. They exceed our current capacity and in some cases could divert resources away from services that matter most to youth, rehabilitation, and public safety. So I'll start with promoting parental engagement at DYRS, the Amendment Act of 2025. DYRS strongly encourages family involvement. It's the foundation of rehabilitation and a vital part of our mission. To that end, we already have systems in place to keep families connected and engaged throughout a young person's commitment. The promoting parental engagement at DYRS Amendment Act wouldn't be difficult to comply with, but the added documentation and reporting requirements would create additional administrative burden. It would require time and resources taken away from actually engaging families. The recently passed ROAD Act has several meetings that require parental engagement, and there's no need to duplicate that requirement in a standalone bill. The strengthening capacity and transparency at DYRS Amendment Act of 2025. DYRS strongly supports transparency, and much of what this bill requires we already report publicly on our website. However, this bill extends well beyond what is practical. The new reporting requirements would necessitate at least one additional FTE, and the time needed to produce and verify this data would detract from our small research team's other essential work. I'm also very concerned about how the bill defines recidivism. It is not tied to arrests or adjudications, but instead to decisions by the Attorney General on whether to file charges. That is not a valid measure of youth behavior or DYRS performance. It's a measure of prosecutorial discretion. Using a definition that differs from national standards would also prevent DYRS from comparing our outcomes to those of other jurisdictions, limiting our ability to align with best practices. I urge Council to align with national standards rather than adopt a definition that measures decisions made by the Attorney General. The bill also requires an overcrowding action plan to be implemented within 120 days and caps the Youth Services Center at no more than 90 youth. This is simply not operationally realistic. The population at YSC is determined by daily activity of the District of Columbia's Superior Court Social Services Division and intake decisions beyond DYRS's control. An arbitrary limit on the number of youth who can be housed at YSC is impossible to enforce, since the courts determine by order to the agency who is detained. Additionally, turning away court-ordered youth from detention, if it was possible, poses an unreasonable risk to the safety of the community. I respect the intent behind this bill, but as written, it places DYRS in an untenable position. It overreaches, and it could have unintended consequences that weaken rather than strengthen our system. I'll turn to the Safe Pregnancy, Delivery, and Postpartum Care for Youth at DYRS Amendment Act of 2025. This act is a bill that DYRS is aligned with. However, we are opposed to enshrining medical guidance into statute. The state of the art in medical care is an ever-changing landscape, best left to medical professionals and the standards that they are legally and ethically required to follow. DYRS is already operating under procedures that align with the intent of and requirements outlined in the bill. We share the Council's commitment to providing comprehensive, compassionate care for pregnant girls and postpartum youth. However, when the standards of care are inevitably updated, the existence of this law will force us to adhere to an outdated standard until the law is changed. Turning to Youth Records Oversight and Transparency Act of 2025. Transparency is essential for maintaining public trust, and Council maintains substantial access to youth records through Secure DC. As it relates to the Council of the District of Columbia, this bill duplicates access already established. However, the Youth Records Oversight and Transparency Amendment Act would expand that access far beyond what is appropriate or necessary in another way. Granting the Office of Ombudsman for Children unrestricted access to all DYRS youth records raises serious concerns. These records often include sensitive and confidential information such as medical, educational, mental health details that must be carefully protected to safeguard youth privacy and comply with confidentiality laws. The purpose of the Ombudsman for Children is to provide oversight of the care and services provided to children who are residents of the district and who are involved with or who are at risk of involvement with the Child and Family Services Agency, and to promote accountability, transparency, and systemic reform within the district's child welfare system. OFC should have access to DYRS information that relates to their oversight role over CFSA and youth who touch both systems. However, granting blanket access to all records expands their access to information well beyond the scope of their mandate. I request the Council clarify and narrow the scope of access provided under this proposal and establish appropriate safeguards to protect youth confidentiality. I'm ready to work with the committee and the Ombudsman for Children to develop a process that strikes a balance between transparency and safeguarding sensitive information while supporting our shared objectives. In conclusion, DYRS remains committed to accountability, transparency, and collaboration with the Council. However, taken together, these bills represent a significant and unnecessary expansion of administrative mandates that would require significant resources to implement. I encourage Council to strike provisions that duplicate existing law, avoid legislating medical standards that should be guided by medical professionals, and collaborate with DYRS and our partner agencies to refine our practices to meet the needs of our youth and Council's oversight role, as DYRS has already demonstrated by implementing the data reporting that is sought after in the strengthening capacity proposal. Through collaboration, we can achieve the goals of these bills in ways that are practical, sustainable, and promote youth care and rehabilitation. Our common goal should be legislation that enhances outcomes without sacrificing safety or overburdening staff capacity. And I'm happy to answer any questions that you have.
Thank you, Director. I'm going to jump right in. And with all due respect, I would just say, out of all of the agencies I'm dealing with, DYRS gives me a little heartburn. I hear the testimony about collaborating, but it's been challenging to collaborate, and I'm happy to go through that. For the Promoting Parental Engagement at DYRS bill, part of your testimony is that you already have these systems in place. This bill is duplicative. These are measures embedded within the Road Act. The reality, though, is you often say, Director, we're meeting with parents regularly. Parents and youth are saying it's not happening. We then say, okay, can you show us proof that you are actually meeting with parents? And there is no proof. What this bill does is not seek to duplicate any systems that are already in place. It requires the agency to maintain a digital log to say, for this detained youth, we engaged this parent in this meeting on this date. I don't think that's a high bar to meet, assuming the agency is actually meeting with parents. I'm happy for you to respond, but it's been challenging to verify and get information. I will go a step further since we're talking about collaboration. I am someone, no surprise, I care about education. I heard directly from the contracted provider for education services at DRS that they did not have sufficient resources to provide the education needed at YSC. YSC, or Youth Services Center, is a 98-bed facility. 98 beds, and at a high water mark, I think we had 130 plus young people in the facility. So, and I'm gonna get to that next, but in the budget, we secured additional funding so that that educational provider could hire more teachers, could purchase equipment, and to date, I don't think that money has been granted or dispersed. In fact, the message we've received from DRS is we don't agree with it. Mind you, when the council passes a budget, that is law. So quite frankly and respectfully, you as director of the agency, you don't get to tell the council, I'm not going to do what you enacted in law. I'll go further. You say on the bill about strengthening capacity and transparency that the requirement for 120 days would somehow jeopardize the operations at Youth Services Center. What that bill is pushing for is that after 120 days of the passage of the bill, the mayor or the deputy mayor or you, the agency, would outline a plan for how you are going to address chronic over capacity at Youth Services Center. Again, for context, it is a 98-bed facility. However, it is routinely over capacity, so much so that young people are sleeping in office spaces in the hospital suite. You are doubling young people in unsafe conditions, and there are heightened incidents as a result of it. I will go further. We are in no way suggesting that DRS release young people early as it relates to this bill. What we are saying is, Mayor Bowser, Director Abid, please outline a plan for how you are going to address overcrowding at YSC, because we deem it unacceptable and it's unsafe. Last thing I would say, because I was a little taken back by your testimony, about the safe pregnancy and delivery and postpartum care. We are in no way suggesting or trying to tie the hands of medical professionals. You suggest that right now there's already guidance on the books to deal with pregnant youth at DRS. When my team reached out to DRS to say, what is the policy? What is the guidance for pregnant youth in DRS? We were told there isn't a policy. When we've reached out about other policies, we are told there isn't a coherent system of policies at DRS. We're kind of piecemealing it. Fine. We're not finger pointing. But again, we are endeavoring to bring our juvenile detention system in alignment with the Department of Corrections, where this is, in fact, a policy. All that to say, I just wanted to level set, because there's often this back and forth. I heard my colleague earlier suggest that these are administrative changes. I heard that as a tenor in some of your testimony, and I strongly reject it. I think what is happening at DRS is problematic. I'm going to use even stronger language. I think what is happening at DYRS is dangerous, and you're failing on your mission. And over the last year, the oversight that I have conducted, we have pinpointed clear gaps in systems, from overcrowding to poor education services to poor intake records to poor parent engagement, and each of these bills are attempting to address those gaps. We've attempted to meet, we've attempted to work collaboratively in good faith. I think you have, for the most part, been a collaborative partner, but I also understand, and this is me talking behind the third wall, that you have higher ups that you have to report to. And so collaboration has been difficult, because every problem we've tried to solve with you, although you've been collaborative, we haven't quite frankly seen traction. So last thing I would just say here, the reason why we have these bills is because when we meet and meet and meet, when I receive complaint after complaint after complaint from parents and youth directly about the conditions and what's happening in the agency, the next step is for us to legislate so it happens. Now, I'm gonna go to my question. I didn't even mean to go on that rant. But I take issue that we have a failing agency, we have overcrowding conditions that are unsafe, we have parents that are decrying that their rights are being abused, and repeatedly we have the agency come here and like, oh, everything's fine, when we know it's not. And I'm not making this up, nor are we trying to overburden the agency just for the sake of doing it. How is DRS currently ensuring that it meets the requirements of the Road Act to invite parents and guardians to predispositions meeting to determine a youth's individualized rehabilitation plan?
Chairman, I think I need to respond to your comments before we get into these questions, because when you say that we haven't responded or we haven't done anything, I'm going to point directly to this bill, the bill that requires us to provide data on our website. All of the data that's encompassed in that bill is now on our website. And we did meet about specifically those individual data points that are articulated in the bill. And the offer you made to me, or the suggestion that you made to me, is if we can collaborate and put this on our website, we won't need to do any legislation on this.
That's great.
And we responded, and that is currently on our website, all of that data that was requested. And for
additional context, there's incident data reports that, quite frankly, maybe don't shed the agency in the best light. And what I was told is, oh, we can't quite do this data reporting because it's going to be a burden for our staff. And so we'll get to it. Is the incident reports on the website?
The incident reporting is on the website.
Okay, we'll take that into consideration. So part of having this in law is that whether Director Abid is there or is someone else, that the agency doesn't get to pick and choose what you're going to opt to do. In terms of educational services, have you dispersed additional funds to the educational provider so that they can hire more staff?
We were in negotiations with the educational provider. We had an agreement at the last meeting that we had, and since then they have withdrawn that agreement. So that's up to them. I can't force them to do anything.
Okay, I think it's a bit of doublespeak, respectfully.
Well, it's not doublespeak, because I think that there is a problem with the council trying to impose terms into a contract.
No, I think what the agency is attempting to do is to get the provider to agree to your terms, which, not to get way in the weeds here, but again, it's the law. Repeatedly, we see executive agencies picking and choosing which laws you're going to abide by. And quite frankly, you don't get to do that. If the council allotted money for the educational provider to hire more teachers, it would be great for the agency to say, this is how we're working with the provider to get more teachers, not to say, we don't agree with this, which is what you all said, so let us renegotiate the contract so we can nullify the original goal. So of course, I'm not surprised that they rejected your offer, because what you're attempting to do is to say, even though it's a 98-bed facility and we may or may not have 120, 125, 130 kids, you're trying to tie their hands so that they can't hire a sufficient number of teachers to provide. That's how I interpret it.
That's not what we're trying to do. We offered additional money both before and after the budget was passed to account for the additional youth that are being housed at YSC. And yes, we did require some changes to the terms of the contract, and we are absolutely within our rights to require those changes.
The
because
Road
to
Act.
do otherwise,
the council passed the Road Act to deal with the very slow process of placing youth, and repeatedly you come to hearings to say we're going to do our best to implement it, which the subtext of that is we're not going to follow the law. We're going to try, but we may not do it. And it's also worth noting from the very beginning, you objected to the Road Act. So again, excuse the passion behind my questioning, but repeatedly you say, let's collaborate, but in the same time, you're going to pick and choose when you're going to do the things worth collaborating on. I'm out of time for this line of questioning. I didn't really get to my questions. I will, but Councilmember Pinto, I'll turn to you.
Okay. Well, thank you. And thank you for your testimony and for being here today. I want to start with the Promoting Parental Engagement bill that we're considering today. And as we think about the impetus for the bill, I mean, how do you think about the current communication processes and existing gaps as you see it in making sure that parents are getting access to the information that they need and that there's a clear, robust line of communication with all those in the ecosystem, whether that be the young person, the parents, legal representatives, and the courts? It would be helpful to hear your perspective of those gaps as we think about the best way to fill them.
So I think that there are numerous places where we are required in the law to engage with families. Now, that doesn't always take place for a variety of reasons. And so I understand the desire to document the efforts. My only point with this is that we do get legislation oftentimes that requires some kind of data reporting, and oftentimes it does not accompany any resources to do it. So we get stretched very thin. As my testimony mentioned, complying with this is not the problem in terms of the family engagement piece. It's the reporting piece that I have concerns about. When we get a notice of intent to commit from either the court or for court social services, this is a youth that is being proceeded against in court, and they're giving us notice. Yeah, we think we're going to commit this young person. We will engage a YLS, which is a youth level of service. It's an evaluation, and that requires meeting with not only the youth but the youth's family. So even before they get committed, we start that engagement. With the Road Act, we have to have a predisposition meeting that requires us to engage with the family. When a youth is released from our care, we do a community placement agreement that requires us to reach out to the family. We have family engagement events. We have a partnership with Parent Watch, who engages with families that are reluctant to work with the agency in a more direct way. We also have a provider called Anchors in Strength that provides support to families and a support group to families. So we have a lot of opportunities where we do engage. I think the only issue I have with the bill itself is to ensure that we get the resources to do the reporting, because what we do, reporting when we have a successful contact with a family member is a lot easier than reporting when we don't, because you have notes in a system that say, all right, we engaged with the family, we did this or we did that. To make it into a report about, well, did you engage at all these occasions, means that we have to have something else that, or individual fields, not in a notes field in a case management system, but some individual field that says yes or no. We had an engagement here, or we had an engagement here, and if we didn't, what was the reason? Did we reach out or all that? What efforts did we make? That's the part that becomes burdensome, and all I'm advocating here for is that we get the resources. If you want to get those reports, I'm certainly open to that. But we shouldn't be tasked with that, because if we don't get those resources, it's going to be those people that are supposed to be engaging with families that are then going to have to develop those individual reports. We don't have a system that can just automatically detect all of that. We would have to build that out.
Okay. And kind of speaking of the balance of new requirements and then fulfilling your existing mission, how have improvements been made over the last year around the rehabilitation plans for each young person?
So the first step in developing those was to do the YLS. We had a significant challenge of resistance from our staff, frankly, to completing those YLSs. So we reorganized the care coordination team to have a dedicated team that exclusively does the YLSs for the agency. And we engaged with a new technical assistance partner to provide quality assurance over that. Once we have a YLS completed, that is what drives the development of a success plan for our young person. And so we have completed that stage where we've now got a dedicated YLS team, and they now are moving into developing these success plans. We do still have work to do in terms of the quality assurance over those plans, ensuring that they're done timely. That still remains to be done. We've also developed a dedicated team for reentry, so that when young people are exiting our system, that they have dedicated workers who are evaluating the work that they've done while they're in commitment to help develop a community placement agreement so that we have the supports in place. We still have to do quality assurance over that as well, but we have made significant progress in putting the pieces together.
Okay, and what does that progress look like in terms of the amount of cases that are in compliance per your own compliance hire?
I'm sorry.
Sorry, that sounded confusing even to me. Now that you have this person in place, what are they finding about how many cases are going through the appropriate
So when we
measures?
look at the YLS completion, what we're finding is when we get notice as it's sort of in the normal course, which is supposed to be 30 days before a youth is committed, we're completing YLSs. But we're also finding that we're getting commitments without a notification prior to their commitment. So there will be situations where a young person is committed because of a plea agreement. So there wasn't an anticipation of whatever happened, and then suddenly that young person's committed. So we've developed a procedure for how to catch up with the work and attempt to do that evaluation that should have been done earlier as quickly as we can while we make efforts to place those youth. We've also made significant strides in expanding the breadth of placement options that we have within the district. As you know, I mean, we have nearly 200 youth that are committed to DYRS, but we only have 60 beds at New Beginnings. So the majority of kids need to be housed in private providers, and private providers can choose to accept the youth or not. So we need to have a range of private providers, and we've had to put a tremendous amount of effort to convince these providers to work with us and to accept youth from our system. And we've made progress there as well.
Okay, and I appreciate all that, but what does that progress look like in terms of the number of kids or the percentage that are in compliance with that planning process?
So, to say they're in compliance, I mean, we are in compliance when we have the proper notification. When we don't have the notification, yes, we're not in compliance with the law because it's impossible to comply with the law in those circumstances. And so we have to just do our best to finish those evaluations and make those placement decisions and work to get those young people placed. We have lots of discussion in Chairman Parker's committee about youth awaiting placement, and that is one of my chief concerns, that we get youth into their programming as quickly as we possibly can. But that means every step of the way we have to make tweaks or make improvements. And so we could have 90% of the work properly done, but if that last 10% something goes wrong, it's still not going to result in the outcome that we want, which is a placement within 30 days. So, it's hard to say like, oh, we haven't made any progress when we have made significant progress. It doesn't always result in the outcome that we're looking for until we get all of those pieces in place and everything lined up. And we're not quite there yet, frankly.
Okay. What do you think the definition of recidivism should be?
It's a new adjudication or conviction in the community. That's what it is. So if you have received treatment from DYRS, you've been a committed youth, and you go back into the community, right? We've released you back into the community, and you obtain a new conviction or a new adjudication of delinquency, which is the equivalent of a conviction in the juvenile parlance.
And how do we square that with what you were saying in your testimony about not being reliant on OAG's prosecutorial discretion in our definition?
So the definition that's in the legislation is looking at what did OAG, did OAG open a new delinquency matter? And the other, section B, is did OAG seek prosecutorial action? And so neither of those gets you to, did they commit a new offense? It's just looking, well, did they open a case, or did they seek to move forward on a case? Recidivism is you got convicted of a new offense. So that it doesn't hit what, it misses the whole point of court, which is like, you can be accused of something, but unless the court finds you guilty, you didn't do it.
Right. I mean, I guess you're saying that recidivism is as though it is totally agreed upon by all. Like, one of the things that we're considering in this bill is around the definition of recidivism, and so I don't think it is. It's not is in the way that maybe it seems obvious to you, because that's kind of one of the topics of.
Well, if I could just elaborate, there is a national definition for recidivism. And there is a lengthy white paper, I believe I've shared it with Chairman Parker's committee, and I can share it with you as well, Chairperson Pinto, that goes into what is that definition and why did they arrive at this definition. And it was put together by a group of scholars and administrators from around the country, and it is the definition that the vast majority of jurisdictions around the country use to define recidivism.
Okay, that's fair. But in our juvenile justice system, when we have the regular use of consent decrees and deferred prosecution agreements and deferred disposition agreements, that will necessarily mean that there are fewer kids who are ultimately adjudicated and convicted by traditional means, because we have those other mechanisms for accountability and response. Wouldn't only defining it as like a final adjudication undercount the challenge that we're trying to measure, which is a repeated offense?
I wouldn't say it's an undercount. That is the accurate count of somebody that recidivated. If you're trying to see a measure of juvenile crime, is there more offenders or more offenses happening, I would suggest you look at arrest rates rather than prosecutorial decisions. I think that's an overcount, but if you want to look at the whole picture, look at arrests and then look at adjudications of delinquency or convictions, and then if you want to get a sense of the magnitude of the new offense, look at reincarceration. Those are the three traditional rates that you would view to sort of see the system and offending behavior, rather than looking at the decisions that the prosecutor makes, because every jurisdiction has a prosecutor that has discretion to do these things.
Yeah, I mean, I would agree that arrests would probably be an overcount, but it just seems to me that a final adjudication could be an undercount. And so this bill seeks to strike a balance, and it appears a reasonable one. Like, if there's and I'm sorry, I know I'm over time here. This will be my last thought on this, but if we have a young person who is rearrested, let's say, for a violent offense, the reason that we want to measure this is to see if our rehabilitation efforts were effective, right? And so this young person has been committed, DYRS, they've been released. 6 months later, they are arrested for a violent offense. They come in, and OAG, with their prosecutorial discretion, looks at all the evidence and determines that they are really better suited for a deferred prosecution agreement, where there's going to be a set of conditions associated with their accountability, and they're not recommitted. Why wouldn't we want to measure that young person as an example of somebody who recidivated? Because by all accounts, they did, right? I mean, not your definition of final adjudication, but that's just because there was a conditions associated with their prosecution.
So, I mean, I think, you know, if somebody is committed to the department and then released and commits a violent offense, I just think it's deferred prosecution is probably not going to be the method that is particularly used unless that allegation of the violent offense is not quite what it seems, right? I mean, we wouldn't take a twice now convicted carjacker and just divert them after they've been through the system, would
Well,
we?
I can't say for sure because I cannot get access to data.
So then you may have an interest in doing that as an
Yes, I
oversight
do.
role
Yes, I
for
do.
OAG. I would just argue that's not recidivism. A recidivism analysis could look at arrests and look at adjudications, but that particular piece is looking at AG's decision-making. That's a different measure, and it's just not recidivism.
Okay,
That shouldn't be a measure of-
I think we might just disagree on
Perhaps we
this.
do.
Because that is what the legislative process is about, right? Is determining what the right standard is for the law. So just because it is not doesn't mean it can't be. And so I just want to make sure that we are focused on the goal that we are trying to accomplish. And maybe this isn't the right standard, but you know, I want us to be creative in figuring out the standard that does address the challenge that we're trying to measure, so that again, it's not just data for data's sake, but so that we can drive towards improvements around these rehabilitative plans. So I won't say I'll stop there now that I'm double over my time, but thank you very much.
Thank you.
No, thank you, and we're being flexible here. Before I jump back into my questions about promoting parental engagement at DRS, the Road Act went into effect as of October 1st. I think what Councilmember Pinto was getting at is how many individualized plans have been created to date?
I don't have data on the Road Act. I was prepared to speak to these bills, and we
But anecdotally.
are still in the recruitment phase of the few additional positions, not sufficient number of additional positions that we were given in that piece of legislation. So we haven't even recruited the people. So we have drafted the procedures, but we cannot implement them until we have the people in place to implement them.
And my team has asked for copies of those protocols that you keep referencing.
We sent those. We didn't send those?
We were told that we would receive them by the end of the year.
Okay.
Can
we'll
we have
make
them?
sure we'll get them to you by tomorrow.
Awesome. And we want to work with you. And this isn't meant to be a gotcha, but again, it's been a little challenging at times. How is DRS currently ensuring that it meets the requirement in the Road Act to invite parents and guardians to a predisposition meeting to determine a youth's individualized rehabilitation plan? And if you want to speak about what the protocol is, even though it may not yet be acting in reality, that's fine.
Right. So it's literally a procedure that requires that we reach out and contact the parents and organize the meeting before that predisposition
And as
hearing takes
director,
place.
how are you verifying that that is happening? So I imagine you're not in each of these meetings. I'm assuming you're planning to look at something to say, are we following our own protocol? How are you ensuring that parents are affirmatively engaged?
So we are putting together a quality assurance process to oversee this. We've required our staff to document that they've reached out and that they've made that effort so that we can see that in the case file. And then, obviously if they choose not to attend, we still have to move forward with their case planning. But we will enforce the rule that they have to reach out and make the request, and then we can review that to ensure that they've made reasonable efforts to engage with them. And there are other engagement opportunities after that. Even if they aren't available or they choose not to participate, we will continue to engage with them. So in terms of the the bill that you have submitted, its spirit, I'm completely aligned with that. It's just a matter of ensuring that we have resources to report on it.
Okay. I think an Excel spreadsheet would be sufficient to simply say, by this date, we contacted this person, they joined this meeting, because I have heard directly from more than a dozen parents that are saying, I don't hear from DRS. DRS made decisions for my child, and I had no idea. I came to visit my young person at Youth Services Center, and wow, I found out once I was there, they're not even there anymore because they were shipped or transferred out, and no one contacted me. My child had COVID. I'm giving real things I've heard. My child had COVID, or my child was sent to the hospital suite and no one notified me. And so I hear from you, yeah, we have these protocols and we're doing it. I hear from parents, it's not happening. The natural question is then, how do we prove, because I want to believe that it's happening, we need some type of documentation to say that the parent engagement is happening. It's not meant to be burdensome. It's not meant to be duplicative. We need to verify that it's happening. How does DRS plan to address instances when a parent doesn't respond? And so I totally agree with you. The process has to keep going. Is that we're going to reach out one time? Is it going to be we're going to reach out 3 times? Maybe a phone is disconnected. Can you just elaborate, if it's hard to get in touch with a parent, how you're going to, what is the protocol around that?
So, obviously we can't know if there is some barrier like that in the moment. And because we have these timeframes, we do have to move on with the case planning. But as I said earlier, we have other opportunities to continue to engage with families. And so at each phase of a youth stay with us, for instance, when we do their success plan, we have to go back and engage with the families. And if we're finding that we can't find them, then yeah, we need to make other efforts, ask other people. We generally will talk to the young person and say, are you in touch with your parent? How do we get in touch with them? And they can give us the information that we need.
Okay, and for additional context, the bill requires that DRS is meeting with parents at least every 6 months, which is essentially twice a year, and that parents are included in the creation of the rehabilitation plan. Those are processes that are already happening. The bill is not requiring new meetings. We're just saying by law you have to, in fact, do it, because we are hearing reports that it's not happening. And the bill requires a digital log, an Excel spreadsheet, a data report, so that there's some proof. So I just want to clarify, we are not trying to add new meetings. These are meetings that should theoretically already be happening that we are including in the law.
So if I could just address the issue of an Excel spreadsheet, that's just not the way we should be doing our business. I know it's in isolation, that sounds like, yeah, reasonable solution. You just do an Excel spreadsheet. But we have multiple people that are going to be responsible for different phases of contact, and they all have to be able to document that information. We do have a case planning system called FamCare. We have to drive all of those things into FamCare. And when we do one-off Excel spreadsheets for this and one-off Excel spreadsheets for that, we don't have a single record that can get everything that we need when we need to research an issue.
That's
if
fair.
You have a question. So that's why I say it's resource, because it is hard to.
But I'm challenged by the argument that, we need 3 extra FTEs to document meetings that are happening that should already be happening. So if I take you at your word, the meetings are happening, it doesn't seem to be that far of a stretch just to record that somewhere.
It's not recording that the meetings are happening. It's when we don't have contact and having a log of all of the efforts. That's the new piece.
Okay. The TDM meetings, we have heard a lot of, these are the team decision meetings. Can you just quickly explain what is the purpose of the TDM meeting at DRS?
The TDM meeting is a meeting that we bring together, team decision making. So we have members of the treatment team, members of the youth's family, to go over the progress of their treatment and their progress on their goals. And yes, there have been issues with the TDM meetings taking place. We have a employee that was out on leave that has now returned and has been made responsible for organizing those TDM meetings, and we are getting those TDM meetings done now.
Okay. And are parents expected to be a part of those TDM meetings?
We would prefer them to be part of the TDM meetings, yes.
Do you have data on how often parents are included in those TDM meetings?
I'll have to check with our team if we have that data.
Okay.
And if we do, I'll provide it.
What the committee routinely hears is that parents are not being invited to be a part of those meetings, and the agency is making decisions for young people outside of the purview of parents. And so again, when we don't have data, it's hard to verify or challenge what we're hearing from parents. How are you recording information as it relates to the TDM meetings? Do you have a software or technology? How is that being recorded?
Yeah, it's recorded in the case management system.
Okay. Now, could that case management system be used to adhere to this law, this bill?
Yes, it could be, but we would need to add additional elements. That's the part that we have to do.
Okay. I'm going to move on to the strengthening capacity and transparency, and I do want to acknowledge we are a little over time. If I could,
absolutely.
Okay, just a little bit more time. I do want to respect your time. This bill is asking, in addition to defining recidivism and reporting out on it annually, it would ask that the executive come up with a plan within 120 days. Now, to your credit, I know you're already thinking about this. We agree that overcrowding at YC is a problem. I know behind the scenes you've been engaging, thinking about how to address the overcrowding issue. This bill is wanting it to be on the public record and to document what the plan is. In your testimony, though, it sounded like you were suggesting the bill is wanting to release young people from detention, and that's not what the bill does.
Okay, so I'll take up the issue of the plan first. We had a hearing on overcrowding.
Yes.
And I did give public testimony about what could we do and what we were doing. And the concern that I have here is that a lot of the decision making about who is detained is outside of DYRS's control. So, we can, let me say, what was the plan that we articulated? Unify the system. That is the best plan that we could go forward with, so that we have an opportunity to.
But you would agree that that's a long-term plan.
Yes.
That's not going to happen anytime soon, especially with our friends down the street.
But there are no short-term options. So acquiring a facility or building a facility are long-term plans as well.
I hesitate to say, I'm not advocating to find more space. There are some that would say DRS finding more space incentivizes us to just lock up more kids. That's not what I'm advocating for. The conditions at YSC are dangerous. I think that is a state of an emergency. It would be great for the mayor, for you, for the deputy mayor to say, here's our short-term plan, whether we're going to send some young people to New Beginnings, whether we're going to use another office space. But the answer can't just be, yeah, we know it's a 98-bed facility and we're 130 and we're going to just keep rocking how we're doing it. Like, that's what I'm hearing you say. This bill is saying within 4 months of this bill passing, the executive has to come up with a short-term plan to address overcrowding at the facility.
You're asking the executive to come up with a plan for things that she doesn't control, and that's the problem. The courts can we can make all the plans that we want, and if they continue to detain youth, we're obligated to house them.
The length of stay due to placement is within the executive's control.
Yes.
To determine whether or not a young person is going to be placed in secure detention or in the community is within, oftentimes, the executive's control. The executive has at its disposal any number of district-owned properties and buildings. It seems to me the executive has a lot of control if the executive thinks this is a problem. If, God forbid, something happens at the YSC facility, I would imagine then there will be a level of urgency that we're just not seeing now. I hear what you're saying. I reject it, because what you're essentially saying is, well, the courts determine who is detained, and so therefore maybe that number will get to 200, 250. Like, we can't operate like that. I'm not suggesting go build a new building, but there should be an emergency plan dealing with overcrowding at YC.
But the bill that you have here puts a cap at 90 days, does it not? I mean, 90 youth at YSC.
It's
says
a 90.
No more than
It's a
90.
98-bed facility. I would have to look at the language. There is no cap in terms of the number of youth detained in the facility.
So I'm going to read from the bill itself that within 120 days and after the effective date, the mayor shall submit council a one-year action plan to address overcrowding. The plan shall specify how the department will permanently reduce the juvenile population at the Youth Services Center to a maximum of 90 youth.
Yeah, to ensure that you are under the capacity of the facility. That in no way is saying that we are requiring the agency to release youth. I want a plan for how you're going to bring the population under the capacity of the facility. I don't think that's rocket science. It's to say 100 people can sit in this room. What's the plan to ensure that we're not over that capacity? I think what is most alarming is that we're treating this as though it's okay. And I would suspect that's informing the rehabilitation or the lack thereof of the young people in custody of DRS, which is in part why our recidivism rates are so high.
Now, I don't think it's okay at all, because I have advocated on numerous occasions about the different populations that we are serving.
If we
I
both
don't
agree
charge
that it's
youth
not
as
okay,
adults.
why is it so hard to come up with a plan to address the problem?
Because we don't have the levers of control to engage a reasonable plan. So I have articulated we need to be given the levers of control. If we could influence the intake decision making, if we could put a structured decision tool about who gets detained overnight and provide that risk assessment to the court so that they can make better decisions, then we could actually influence.
I fully support the goal of unification. I'm with you, but that's a long-term proposition at best. The facility is overcrowded now. It has been overcrowded for years. And again, we're talking past each other, but I just think it is not a good look for the executive's formal testimony to be, it's out of our control to deal with overcrowding at DRS. That cannot be the...
Our position is that we should be given control so that we can influence that population. It isn't we're not structured properly, and so we should move to structure the agency.
I would
with
just
the
say
levers
we
that
have, as a council, interestingly enough, been blamed, but also asked to pass emergencies, to enforce a curfew, and to detain youth for this or that or the other. And so it is just curious that we can move with urgency when we want to penalize young people, but when it is about ensuring their well-being, there just seems to be a lack of urgency.
The curfew doesn't impact the detention population. Those youth are not detained.
But I'm talking about, I would argue, a lot of the young people probably running around the city, I would imagine a fraction of them have encountered DRS. This is tangential to my point. The argument I'm making is we can move swiftly on an emergency basis when we want to. We could treat things urgently when we want to, and we should. It's curious that we're not treating overcrowding at YSC as an urgent crisis. I think it's an urgent crisis. This bill is asking the mayor in 4 months after this bill is passed to come up with a plan. There should be a plan right now. It's not rocket science. I'm going to keep going. But I want to make clear on this. We in no way are advocating for the release of juveniles in detention. I don't want the narrative to be, oh, you know, those soft on crime council members are trying to ensure we don't detain youth. That is not the nature or the purpose of the bill. It is to ensure that it's not overcrowding at YSC.
So that 90-day cap is not a cap? Is that what it...
It's not about 90 days.
If there's 90 youth maximum capacity?
To come up with a plan
But if we say in law that we can only house 90 youth at this facility.
That's not what we're asking for. We're asking for a plan, not a law. We're asking for what is your plan to ensure that there are no more than 90 youth housed at YSC at any given time. What is the plan? Not change the law, not release anyone, to ensure that there are sufficient resources. Now, this dovetails with the education thing we were talking about before, because the education provider would say, we are contracted to provide education services, assuming there are 98 youth at the facility. We don't have enough teachers when there are 130 youth at the facility. That makes a lot of sense to me as a former teacher. I can't teach 100 kids at one time. We provided more resources so that DRS can provide resources to the education provider so that they can hire more teachers. We've gone through this already. It's all connected. But DRS's position is, well, we don't think they deserve more money. And
that's not true. We offered substantially more funding for the additional population. They chose to walk away from that.
Okay. I'm going to keep moving. I'm going to keep going. The safe pregnancy, delivery, and postpartum care. Does DRS have any internal policies for pregnant youth at this moment?
We have a draft policy. We do not have an implemented policy.
Okay,
I can
so
provide
this
the draft
bill,
policy.
and essentially your testimony was this bill is not necessary. This bill requires DRS to have a policy. So right now DRS does not have a policy. Maybe you don't need a bill to tell you to create a policy, but it's not duplicative because right now you don't have a policy.
No, the point that I'm making about this is that you're enshrining the current medical standards into a law. And those are things that change over time. Medical standards are not static. They change. So in any case, when any youth comes to us, whether we have a procedure that covers it or not, we have physicians and nurses that have medical licenses, and they have ethical obligations, professional obligations to provide a standard of care, and they provide that standard of care. Now, we can articulate that standard in whether it's for pregnant women or for other populations, but it doesn't absolve them of that responsibility. They always have that responsibility. So what I'm saying is if we enshrine this into law and then the standards change, then now we're stuck with these standards and we have to come back and change the bill.
What standards? I'm not following.
These are standards of care for a pregnant youth.
We are asking the agency to create a policy, provide pregnancy tests before the administration of any medication, because right now it is our understanding that, well, let me ask, how often are pregnancy tests provided to young people at DRS?
They will be provided to every youth, but they have not been provided to everyone that comes in.
Okay, so we don't have a plan. There are no pregnancy tests provided.
No, they are provided now. I said that they were not provided in the past. We have updated that, and we are ensuring that young ladies that come in do get a pregnancy test.
And so you would agree that that is important. All this is doing is ensuring that whether Director Abed is here or somebody else who may not agree with that, that is the standard. That's all. We're not trying to overburden. And again, we're bringing our juvenile detention system in alignment with what we do at the Department of Corrections.
Understood.
Okay.
And just for the record, I don't disagree with anything that's in that bill.
Okay.
In terms of the care of young people.
Okay. On the recidivism front, I hear what you're saying, and I'm persuaded by it. Essentially, what I think I hear you say is our definition of recidivism should be about the harm caused by a young person for a new offense once they are released from detention, not simply whether or not the OAG presses charges. The challenge, though, is how do we get data to inform our metric of recidivism outside of the data that the OAG would be collecting?
Well, so, MPD has arrest data on juvenile offenses. So we have arrest data, and I totally agree that is not recidivism, if you will, because it is essentially an allegation, right, that a young person has committed an offense. The objective way to determine, well, did you actually do that, right, versus the allegation is the court process. if you're adjudicated delinquent, if you're convicted of an offense, then the law says, yes, you have done that. That is exactly what the trial is. They are a trier of fact. They are determining this is what actually happened. That's the record now. And so that is what I would measure objectively as a recidivist. So, looking at the decision-making of the OAG is sort of, well, how did they subjectively decide to handle this case or divert that case? I don't know what that really shows, counsel for the performance of DYRS, because that's really just their decision-making. And I don't know, you may have a legitimate interest in overseeing the AG about their decision-making.
Mm-hmm.
I'm just saying that that's not a definition for recidivism. It's just a measure of OAG.
As we move forward, I would love to work with you and your team, but to strike the right balance there, because I think what you're saying makes a lot of sense, and I think there's probably a balance somewhere in there. For the sake of time, I'm just going to, at a high level, so the promoting parental engagement at DRS, the headline I have from you all is a lot of this is or already planning to take place in terms of these parent meetings, and we're fine with logging the parent meetings. We just need the resources to do that.
Absolutely.
Okay, that's fair. The strengthening capacity and transparency, maybe we just don't agree here. That would require a plan from the executive within 120 days of the passage of this bill. It would define recidivism and ensure that we're tracking that as a metric. The headline that I have is that your plan is unifying our system, there's no need to create a plan within 120 days. Is that fair?
Well, for the entirety of that bill, I would like to also say first, there are a number of data requirements that are in that bill that the department has already stepped forward and begun reporting on.
And I appreciate that.
And those are on our website. So to that extent, we're already in compliance with what's being requested. We've already talked about the recidivism definitions. I think we just have a difference, or I don't think we have much of a difference, but
and we'll align on
with
that.
with the language.
Seems like the greatest distance is on creating a plan to address overcrowding.
Yes, because we've had that hearing, and I've articulated that, and we can articulate it in a document. I understand
Yes.
what you're asking for,
And ideally take action.
But what I want to impress upon you is that when we're looking at the population and you're just looking at DYRS, you're missing the bigger picture. The contributors in there are the ones that we really need to address, and that never gets addressed, and that's where we get
the contributors
the friction.
Being the courts, I'm assuming you.
The courts, court social services, the controls that you would typically put in place to manage a detention population don't exist with DYRS. They exist within these other entities.
And that is, I take that. As you know, we don't have jurisdiction or oversight over the federal government. Our courts and court social services are federal entities. I certainly meet with them. We do have jurisdiction over DRS. And so I do think there are things we could be doing in the district to address dangerous overcrowding at YC, which is what this bill seeks to do. And then the Safe Pregnancy, Delivery, and Postpartum Care Bill, it sounds like generally we are aligned now that it's good to have a policy in place and provide pregnancy tests, and it sounds like you all are already in the work there. Is that fair?
That's correct.
Okay. On the education funding matter, I know that's not relative to these bills, but it matters a lot to me. And the reason, just for those watching, what I saw at YSC, and I know there's some disagreement here, but I saw young people being handed a worksheet, and that was the extent of their education services provided that day, with no guidance, no teaching. And part of why, after we did some investigating, I was told that was happening is because the educational provider didn't have sufficient number of teachers. Okay, let's solve that. We'll give you more money so you can hire more teachers. I won't belabor the point because I think I've made the point, but I would just say, Director, every day a young person at YSC is not receiving adequate education services, I think is to their detriment and to the city's detriment. And I hope I will be working with you all to come up with some agreement, but I just continue to be challenged that we can't just disperse the money for the agency to be able to hire more teachers. I don't think it's that difficult. I know I'm oversimplifying it, but I'll give you the last word there. But it's now November and we still don't have more education staff at the facility.
Mr. Chairman, I think that having these conversations in public has been one of the barriers to getting to an agreement. As I mentioned, we had an agreement prior to our last meeting.
I reject that.
And
I reject it. I don't buy it. I don't, and so I
mean,
think
you
there's
can reject it, but we've been in earnest negotiations with the provider. What we can't do is just give money or pump money into a contract. There are legal requirements for a contract, but you're saying no, just give this money to this particular vendor, and
the executive every day reprograms money. Every day renegotiates contracts. We have to approve it all of the time. This is not some one-off decision. I'm not asking you to strike a new deal with them. We acted swiftly because we had communication with you. We talked to them. We said what is needed. I think the dollar amount was $200,000, $300,000, which in the grand scheme of things isn't a ton of money, so that they can hire X more teachers at the facility. Let me ask this, is every young person at YSC provided in-person instruction every day?
Once they're out of intake, yes. But the first 5 days, we don't have their education records. They do not get instruction until we get their education records.
So you are saying every young person is receiving in-person direct instruction, and no longer are young people receiving these worksheets?
Yes, what we do is when, if we have too many youth for a particular unit, they still go into the classroom and get their education during the day, even if they're not housed in that particular unit. So we have found a solution.
What I saw.
Well, I think that you were seeing youth that were in that 5-day period in the intake portion of the facility. And I have looked and drilled down on this issue. Youth are getting their education. It's when we move them into their unit, they get their education, and we move them into that after the 5-day period. That's the way that we've been operating.
I'll end on a positive note, but again, for context, there are about 11 youth on one unit. The youth could range in age from, let's say, 14 to 17. 11 young people at all different ages, oftentimes with one teacher that's pushing in to provide what I would call subpar education. That is what is happening. Now, kudos to you. We talked about earlier this year, can you use technology to provide more individualized instruction at that young person's level so that they're receiving an adequate education? And I'll give you credit, you've done that. And so we're pushing at this because I think when we talk about rehabilitation, education plays a major part in that, in my opinion. I think there's still some more work to do, and we can handle that offline. I don't know where Councilmember Pinto went, and I don't see any of my colleagues, but I want to thank you for your time and testimony on these bills. We will keep pushing, but I will just end by saying again, each of these bills address very distinct gaps that we have identified over our year plus of oversight of the agency. So thank you again, Director.
Thank you, Mr. Chairman.
With that, the time is now 12:44. I am going to recess for 6 minutes and resume this hearing with public witnesses at 12:50. And so with that, we will recess and resume in 6 minutes. I am going to call this hearing back into order. And I'm going to ask if people in the chamber could quiet down as we move on to our public witnesses. First, we have Jamari Kane White. Next, Sierra Bailey, Princess Sims, Olivia Thomas. And Jamari, you may begin when you're ready. For this panel, that will be it.
Hello. Okay. Good afternoon, everyone. Good afternoon, Councilmember Parker. And here we are again to discuss the Soul Family Initiative. I'm glad we were holding this joint hearing. So I am Jamari White. I am a native Washingtonian and recent Howard University graduate. I've lived here and occasionally Maryland my entire life. I've also spent half of my life in foster care up until 2020 when I was adopted at the age of 19. During my tenure in the system, I had about 10 placements, various foster homes, congregate care settings, failed kinship, even almost missed out on my loving family if I hadn't come to my senses and realized those people love me more than anyone. And they continue to show it day in and day out, no matter what situation I'm in. I'll always ask my parents for help. But I dream of that feeling for every youth in care. Unfortunately, most older youth here in our city age out or choose emancipation because they never experienced that love, nor do they believe it exists after their traumatic experiences within the system. Such as the state I was in before meeting my family. Experiences that could be avoided if we enact the Soul Family Initiative and move it forward. This permanency pathway will essentially allow youth to choose their family, building lifelong connections with their most trusted adults. And quite frankly, the system now feels more like a lottery system where some children have the loving foster care experience that's so coveted, while others have to endure hardships to no end, ultimately finding their own way in life after being thrown out the system at age 21, regardless of if they are ready or not. A trend that should not be so consistent. A trend that would have saved me years of trauma and otherwise negative experiences with parental figures. I watched every adult I actually wanted to live with pass the opportunity up due to financial anxiety, the process of being too drawn out, not having their things together, etc. My father had passed as soon as my little brother was born. My father had passed as soon as my little brother was born, not having things together, and we just couldn't be taken by anyone because various loopholes such as my aunt not having her name on the lease, grandma couldn't take me because she didn't have enough money, and etc. The supports just were not in place. And I found what I thought to be a great home in my father's sister's home, only for the kinship to fail. And as you know, most prospective foster parents would like a younger child, one that's easily moldable, and not a teen who's trying to find a way in the world. So I was separated from my younger brother and tossed in a group home. I begged for a lifeline every day in the group home, almost to the point of tallying the walls. Every adult I had a meaningful relationship with could not take me due to the complications of the guardianship process or financial strain. Now, where my story differs is I went back to my now family on my own, and they accepted me back. If they hadn't, my fate would have been much like that of my peers, aged out, incarcerated. Some were even trafficked, and others had the life squeezed out of them and only wanted to get money to survive. And we can get coffee and discuss those things later, but the point is we need the Soul Family Initiative. The city's youth needs the Soul Family Initiative. This is the most transformative legislation I've seen in all my years of living as it relates to the child welfare system. It takes a village, and this gives youth the keys to build their own. Leaving the system early, know what a family is, knowing people have your back and it's not against the wall. A shorter process that is less invasive and more open to be trusted by youth and adults. By allowing youth to live with one member and having others support where they can is the ultimate way of letting the youth decide their pathway as opposed to feeling like just lambs to the slaughter. This will help ensure many of our city's youth can envision a future for themselves beyond where their next meal is coming from. A future where death, incarceration, or being trafficked hasn't even entered their minds because they are so entrenched in love. During my public speaking appearances, panels, and all, I've come across many nonprofit directors and professionals alike, and I've always heard long, drawn-out plans, many of which are feasible. However, the Soul Family Initiative, it is a no-brainer. Me and all the youth who've actually experienced the system feel the same. It is the ultimate way of letting youth be in control of their life when many of them feel quite the opposite. It is the ultimate way of showing youth that people will still stand with them instead of demonizing them here in our city. That is why me and my peers give all the time we have to advocating for this initiative. Our time in the system may have passed, but it's not just about our experiences. We are trying to ensure that our ordeals are not consistencies in this system. This is for all the youth who are trying to and will come to innovate even more than we could ever imagine. By passing the Soul Family Permanency Pathway, you'll be doing a great justice to our city and the foster youth who inhabit it. Thank you.
Thank you. I gave you a little extra time. If you could just push the button to make sure you turn your mic off. And then next, we will have Sierra Bailey.
Good morning. Good morning, Chairperson Parker, Chairperson Pintos, and members of the committee. My name is Sierra Bailey, and I am a LIV expert from Washington, D.C., testifying today in support of the Soul Amendment Act of 2025. When I first heard about Soul, there were three parts that stood out to me. One was that you got to take initiative over your own life by building your community or family, if you will. I'm from a big family. I'm one of 10, and although we all went into care at a young age, I still value and share strong bonds with them. I know all too well the benefit of having a family and support around you. Another huge part of it was the name: support, opportunity, unity, and legal relationships. I believe we named it this to encompass all of the things that it takes to make a family real. Soul isn't just another saying or a name made up to sound catchy. It gives life to a thing that was created for the youth of the system today with community and resources in mind, intent on creating forever families. The last major one was I had never heard of youth leading the process and advocating for what they wanted for themselves. It would have been ideal if Soul could have been an option for me personally, because I had a lot of people who loved me, but at the time I did not feel like I wanted to disassociate with my siblings for the sake of permanency. But since it could not be an option for me, I would like to say why I think it should be passed into legislation here today for the current youth of today's system. I've been working on Soul with CFSA, OAG, and other professionals and LIV experts for about a year and a half, sharing ideas, creating policy, and building practice and implementation plans. The LIV experts who are currently in care drive me the most. In my experience in working with them, the current youth seem a lot more insightful about their rights, permanency options, planning for the future, and they are adamant about being the change they would like to see, which is a lot different from when I aged out in November 2019. I wanted to be a part of helping them do that for themselves and also being a part of how we implement that moving forward in the best way. I personally feel like the current permanency plans do not fully address the current climate for the older youth in care and who are aging out of care. We have young adults who are faced with choosing services or community. For Soul, we are talking about older youth between the ages of 16 and 21 without a permanency option that includes a family. APLA is not a permanency plan. It's a plan to say we have no plan. With Soul, we do have one that sets the youth up for now as well as in the future. I do not know how much it will cost, but I know that it will save DC some money. The estimated annual cost of Soul Family is about half for the cost of the current foster care placement. We want to create a real permanency plan for all youth. The more people, the bigger the community, the better it is. The reality is you can have all the services in the world, but if you don't have a community to teach you basic skills, then you won't be able to reach your full potential. Youth with APLA age out with resources for housing, insurance, but they don't have a community to help them do small things like applying for apartments in their range, moving into their apartment, and even signing a lease. You need somebody to teach you about life. When I aged out, I had support. I had a mentor. I had DCFYI. I had siblings. He helped me at the highest of highs. With me, the birth of my son, he was there, and now he's the godson of my father. He brought me books, my son, I'm sorry, bringing me books and holding my son while I was resting. He taught me how to be a woman, how to be an adult, and a lot of our youth don't have that. I think about it now, and it's heartbreaking. I ask the committee to please move this SOL legislation forward as soon as possible. Thank you.
Thank you. Well, you got a round of applause. Since there's an empty chair now, I'm going to ask Zanaya Torres to join. But next, we're going to hear from Olivia Thomas. And if you can make sure you speak into the microphone and the light is on.
Okay, is this good?
Yep.
All right. Good afternoon, Councilmember Parker and member of the committee. My name is Olivia Thomas. I am 18 years old and from Washington, D.C. But honestly, I like to say that I'm a little bit from everywhere. I spent a good time of my life in Baltimore, too, and I've also been connected to D.C. I got in foster care when I was going to the 7th grade, and I've been in and out ever since. This past summer, I was adopted, and that was a huge moment for me. I finally felt like I had the family and stability I've always wanted my whole life. I'm here today to speak in support of the SOL legislation. I'm a Lex leader, and I was part of helping build this idea because I really believe in what SOL stands for. For me, SOL means having a family that goes beyond just blood. It's about having people who love you, support you, and stay in your life no matter what. Youth like me need that. There are so many young people in the system who age out without the permanent support system. SOL gives them a chance to create their own version of a family, people who make them feel safe, wanted, and loved even after their case closes. One thing I think that should be changing the bill is that it shouldn't be on the youth to explain why certain adults disagree with their SOL family choices. That puts too much pressure on us. Adults should be responsible for explaining their own reasons, not the youth. I want to thank Councilmember Parker for introducing this bill and all the other members who co-sponsored it, including Councilmember Pinto, Louis George, Allen, Robert White, and Nadu. I really hope you all move this legislation forward because it could make a difference for so many of us in care who just want to know we'll always have someone in our corner. Thank you for listening to me and my story and for supporting youth like me.
Thank you. With a minute to spare. So thank you. Next, we will have, I'm sorry, Princess. Did I skip you? Okay, I'm sorry. I didn't mean to do that. Next, I'll have Princess Sims.
No shade, no shade.
No shade.
Good afternoon, Chairman Parker and members of the committee. My name is Princess Ariel Loveland Sims. I'm one of the former foster youth, now lived expert, who for the past 2 years has worked diligently on creating and designing SOL, essentially bringing it to life. I am testifying today in support of the SOL legislation. I entered foster care when I was 16 years old, but I had experienced neglect and abuse as young as 5. I have been in the juvenile justice system, group homes, experienced being a runaway and having to couch surf even while in care. I stayed in the system until I aged out at 21. Even after finding good foster parents towards the end of my foster care journey, there was not enough support to strengthen and maintain the bonds created. So I decided to venture out on my own without the default support system that is supposed to be available for youth when they age out, otherwise known as APLA. I am supportive of the SOL family option because of its uniqueness. SOL is tailored to a youth's individual needs. SOL can grow with a youth because of its flexibility to adjust and shift based on what a youth's needs are at the time. The term SOL family is important to me because your SOL family is not just supporting you, they are also providing opportunities, unity, and creating legal relationships. A support family, as currently written in the legislation, sounds separate from the family. SOL is the family. The term support itself is generic. Additionally, we took a lot of time and put a lot of thought into creating that term, and I believe it should be well respected, just the same as any title you earned or name you create. It is not fair for it to be shortened or abbreviated by people that did not have a hand in creating it and who will not be directly impacted by it. No shade, no shade. Now more than ever, strengthening familiar bonds and providing youth with positive outlets is especially important. You should be able to build, create, and receive support from your own community as quickly as possible. It has always been urgent, but in this day and age, it is ever now more so. I ask this committee to please move the proposed SOUL legislation forward. The future of the youth of tomorrow begins with our efforts today. Thank you graciously for your time and consideration.
Thank you. And no shade taken. Next, we will hear from Zanaya Torres.
Good afternoon. Good afternoon, council members.
If you could just make sure you speak directly into the mic.
Good afternoon, council members. Can you hear me?
Yes, but if you could project, or yeah, let's use this one. And make sure you turn that one off. So it's there.
Can you hear me? Is it still?
Uh-oh. Okay, let's just go to the original one, and if you could project as much as possible, we'll make it work.
Good afternoon. Okay.
That's good.
So my name is Zanaya Torres, and I'm a Lex leader. I'm 18 years old, and I'm a DC resident who is currently in care. I'm here today to testify in support of SOUL legislation, and I want to thank Councilmember Parker for introducing it, along with Councilmembers Pinto, Janice Lewis-George, Charles Allen, Robert White, and Brianne Neto for co-sponsoring. As a Lex leader, I collaborated with others to develop the legislation and contributed to the development of the SOUL concept. SOUL is deeply meaningful to us because it embodies what we all need and deserve: a sense of love, belonging, and a lasting family, even after foster care. The name SOUL is significant because it stands for support, opportunity, unity, and legal relationships. And this signifies a relationship that goes beyond the name support. For this reason, it is crucial that the word SOUL remains in the legislation and not be substituted with support. I believe that words matter, and SOUL reflects the purpose behind our efforts. Furthermore, the term support will conflict with our other terminology, such as supporters. We want this legislation to move forward and pass because it offers young people in foster care a genuine opportunity to create enduring, chosen familial connections that continue after the system ends. I have firsthand experience, and I know how difficult it can be to be without a network of support, and it is evident that youth are purposely aging out with other permanency options. By empowering young people to shape their own families and futures, SOUL works to alter that. The mission of SOUL is to empower youth and allow them to feel comfortable with their decisions and to choose their family by giving them autonomy to create it. Additionally, I would like to recommend one key modification. As of the moment, legislation says that youth must explain why an adult disagrees with the proposed SOUL family, and I think this puts too much responsibility and emotional burden on the youth. The adult who disagrees should have the responsibility of explaining why the youth isn't supported. Instead of making young people feel blamed or overwhelmed, I think the process should uplift them. Lastly, I urge the council to ensure that SOUL supporters get to take part in the process without having access to all the confidential records related to the neglect case. It is crucial to protect the privacy and the dignity of the youth, and I think that we can still do that while allowing meaningful participation. Thank you again to Councilmember Parker and all of the co-sponsors for supporting this vision. Please move this legislation forward soon as possible, so DC youth in foster care can finally have what every young person deserves, which is a permanent family and a sense of belonging through SOUL. Thank you.
Thank you all. We will ask a round of questions each. And I just have two simple questions. How do you believe, can you give one specific way you believe this legislation can empower older foster youth who are at risk of aging out of the system? And feel free to answer in any order. If you could push the button so your microphone.
What I'll say is a lot of older youth are staying in the system, as she mentioned, purposely for services. If you affirm a youth to say, this is where I want to go, this is where they're ultimately going to go when they're 21 anyway. It's been proven, like, when you turn 21, it's a lot of places that you could not go when you were in care, a lot of homes that you couldn't be in because of different licensing.
Can you say more about, what do you mean youth are choosing to stay in the system?
Because basically we're choosing to age out. Like, I did the same thing. I'm speaking specifically because I was one of them. I specifically chose not to do adoption. I already knew adoption wasn't for me, so I aged out in independent living. I didn't even want a foster parent. I didn't want to live with anybody. I didn't want to be around anybody else, but I needed the services. I needed FUP. I needed insurance, and I turned 28 in a few days, and I still have it. These are things that I needed because without it, I did not have a community to lay the foundation for me. I needed help. So I stayed in foster care when I could have aged out. I mean, I had jobs and different things like that to get apartments, but I needed the services part. And part of it was I didn't even know how to apply the services. You gave me a voucher, but didn't even tell me that I had to apply to apartments, and not even knowing which ones I could apply to. This is why you need community. This is the reality of where we have kids choosing, like, where am I gonna go? Where am I gonna be? What am I gonna do?
And as part of the challenge with adoption, that you don't have a choice in the matter?
I think it's twofold, right? I think when you're older and you're in the foster care system, is adoption present for you? Like, is it something that they're pursuing for you or you're pursuing for yourself? Even if your goal is adoption, at a certain age, is it realistic for you or the families that you're coming and sitting around at a certain age personally? And I know people who've been adopted at 30 years old. I'm not saying that they're wrong or their family didn't care about them, right? That's not what I'm saying. But I'm saying that situation doesn't happen a lot of times for most of our youth.
Understood. And Princess, you wanted to jump in?
Yeah, I wanted to speak a little bit just about like what you necessarily mean by like a choice. So youth can choose to emancipate at age 16. You can choose to emancipate yourself from the foster care agency at 18. But oftentimes they do choose to stay within the agency because, let's say like, you're like Olivia, you go, you get adopted, everything's going well. But then what happens when things don't? What happens when you get into a really big argument or fight or something with your, chosen family and you don't have any of those services. You don't have any of those supports. You don't have anybody you can turn to. It's between you and whoever you're living with at the time. And especially like when you're even faced with being in somebody's foster home, you're at their whim in a sense because you don't necessarily get to make any real decisions for yourself. You didn't get to choose that foster parent. You don't really get to choose how long you really get to stay with them. When you age out at 21, that's solely up to you or between you and that foster parent, whether you get to stay there or not. Even when you get adoption finalized, they can still choose to kick you out and say, hey, well, on paperwork, you're my family. So their choice is somewhat of an illusion. So they choose the lesser evil, what actually gives them the most control, the most sense of power to be able to choose what happens to them in the future. And, of course, like we've been consistently reiterating, with SOUL, you won't have to choose between those services and supports. You'll be able to have that autonomy of family, and it won't just be you and whoever you're living with. It'll be whoever you choose to be a part of your SOUL family, and they will all have legal ties to you, and they will all be able to support you. And not only that, but to be able to say, we're not just going to throw you in somebody's home and say, go figure it out for yourself. To be able to say, we're going to help you navigate the system. We're all going to help support you, and we're all going to be having your back, so that way you never feel like you only have one choice.
Understood. Well, I want to say, did you want to jump in? I'm being really lenient with the clock, but that's only because I really appreciate the work that you all did to draft this legislation.
I definitely believe that most youth decide to age out due to the fact that they feel like they cannot create a new family or a new family dynamic. And I can speak from experience myself. I have seen so many children decide that they want to age out only because of the fact that they don't think that the person that they're living with, whether that's your foster parent or the person you're doing guardianship with, or your adoptive parent, is going to completely take that role of your birth parent. And I could say for myself, I feel like I had to age out because I know that I will never really be able to find that relationship that I have with my mother, or the relationship I'm supposed to have with my mother, with my foster parent at the moment. So I don't know. I just feel like when you have a normal relationship with like a child and a parent, there's certain things that are expected, and I just feel like a lot of kids don't feel like that is guaranteed. And I feel like that's why they kind of shorthand themselves of creating that relationship or even being dependent, and that's why they look towards these services instead of trying to find a foundation within these other people.
Makes a lot of sense. One other quick question, if you can just answer briefly while I have you. What I hear you all talking about is to improve youth well-being in the within the foster system through the SOUL Act. There's a lot of discussion generally around young people across the district. What should we as a government be thinking about or doing, not just for youth in the system, but just young people in general? I'm thinking of, we just acted on the youth curfew. I'm not asking you to weigh in on that, but what's top of mind is youth well-being. Thoughts, reactions, what should we be doing?
I believe that we should be informing youth of their rights and generally just educating them on what they're entitled to, what supports are available to them, and what outlets are available to them. I cannot tell you how many times when I was a teenager, oftentimes my friends and me, we would get into trouble simply because we had nothing else to do. Like, not to get too nitty gritty, but I literally became a stripper because I was bored and I was getting kicked out of my foster mother's house. And literally, there was like nothing else to do. I would try to go to the library, and they said because I was 18 that I could not go to the library before 3 o'clock. But my foster mother was kicking me out at 10 o'clock in the morning, every morning. And every night she would say, you can't come home. And I decided to go to a strip club because when I would ask around what other, what other services are out there, what other, things are there to do, what other activities are available. And I kept using the money I earned from that to get my own hotel rooms and to house not only me, but several of my other friends who were not in foster care, but that were also same age as me, getting kicked out of their homes, having nowhere to go, laying in Union Station, laying on sidewalks and benches, and that would dance on the street corners for money because they had absolutely nowhere to go and absolutely nothing to do. I'm not saying that the end-all be-all will be, okay, when they are aware of their rights or when they know what rec centers to go to, or even if you point them to the right services and supports, that'll be the only answer, but it is a huge answer and a huge step in the right direction. Oftentimes I ask teenagers, like, why do you destroy this? Why do you go there? Why do you do that? Why do you feel the need to stay house away? Because they have nowhere to go, because they have nothing else to do, because they have no one supporting them or saying, hey, instead of going to go and learn how to roll a J, how about you learn how to do some robotics? How about you learn how to take these chess classes that are free at the library? I literally went to the library the other day just to go work on my testimony, and I was stumbling trying to find the bathroom, and I literally came across this program called Dream Lab, and they literally offer 3D printing classes, Cricut classes to teach you how to make your own stickers and whatnot, teaching classes on how to do audio and visual. You have so many young people out here that want to be rappers, and you can literally learn the audio and visual tech and become the engineer, become the owners, become so much more than what is initially offered, but they do not know. They're not aware of what is actually available. And that was like 5 minutes down the street from the strip club I was working at.
Understood.
And nobody told me that. It was there.
Understood. Thank you. I didn't want to have young people here and not take advantage of the opportunity to ask about what's top of mind for all of us in government. I'm going to turn to my colleague, Councilmember Pinto, for a round of questions.
Great. Thank you, Chairman Parker, and thank you all for being here today and all of your extremely important work, and congratulations on putting this bill together. And as far as we've gotten, it is a real testament to all of your courage and intellect and commitment to making improvements for the system for everybody. And so thank you very much. I guess just following up on that conversation around making sure young people are aware of the opportunities and the programs that we have in DC. What is the best way to reach young people with that information? We try to do some education with our schools. We post things on social media. I think we need to do more of, flyering in various communities. But how should we be getting the information to where it needs to go?
I think social media is also a good place, and maybe actually going out to people personally, not just doing social media, how we are interacting today. I think you guys should actually go to different wards. I'm in Ward 8. I don't see a lot of people trying to see things they could do for us or how they can help us. For me, how I stay out of stuff, honestly, I'm in band. I go to Baloo. That's kind of what I do, and I notice all the time, a lot of people don't, have anything to do after school. They go roll J's, like Princess said. They don't do anything. So I feel like if y'all just went to schools, if y'all actually like stayed, you know, like going to other schools, things would like probably change. And not just being like on this side of town, actually going like to the south side or something else.
Okay, go ahead.
I just want to note that children are going to be children regardless, and I do feel like even if things were on social media, I feel like teenagers or young adults probably wouldn't look directly towards that due to the fact that, like I said, kids are going to hang out with their friends after school, and they're going to do certain things that they want to do, whatever their piques their interest. I personally felt like when I was like younger, I would usually find like most of my activities from either my social worker or my GAL or even my foster parent in general. And, you know, I feel like especially if you have some type of relationship, you know, that those type of people can suggest certain things that you might want to do. They can even do those things with you. And I feel like, you know, I feel like that would also help as well. So.
Thank you.
I just want to briefly state, I think also getting the adults to engage with the youth, not just saying, here you go do this, get out my face. I cannot tell you how many times my fiance's son, he do not want to read books at all. He will not read, but let me read it in a funny voice, or let me read it with him, or let me, you know, actually allow him the time to sound out the words, or even let me throw in a couple of funny terms like 6, 7 in there, and it'll engage him because that's something he can relate to. A lot oftentimes, nobody knows what it means. Like, honestly, it's just a coin term that like, you know, being able to like it caught your engagement though. Look, see, stuff like that. It caught everybody's engagement. Now everybody's, wait, let me pay attention, because that's a term that everybody has heard. That's a term that kids have popularly, you know, socialized on social media. Being able to have those little fun interactions and stop putting up these barriers like, I'm above you, I'm separate from you. You all used to be our age at some point or another. And now it's your job to be able to maybe turn the hands of time backwards just a little bit and actually engage with the youth. Actually, you know, take off the suits a little bit and throw on the sneakers and be able to say, we're not just going to tell you, go do this, get out of my face, and go be a productive citizen of society, but to be able to say, we are the society, and we are one, and we need to stand together as one, not as separate entities that stand as a pyramid scheme just trying to topple each other.
Thank you. Go ahead.
I'm a mom, so I will say, I want to say one thing. Representation is very important. You don't see enough people in our neighborhoods doing good work. If you want somebody to do good, you have to show them that there's good to do, right? I'll say, my brother just got sentenced to 24 years, and I don't want anybody that's in the system or not to have that same fate. There has to be something done. And I'm not saying that there isn't supports out here that are available, but you have to affirm a youth enough for them to want to do it, to be honest with themselves enough to change and be something different from their reality. We have to do something.
Very powerful. Thank you. Thank you all very much.
Thank you for your testimony. Thank you.
Thank you.
6-7. I'm gonna have to add that to my list.
I'm so happy that 6-7 is now officially becoming part of the legislative record, which will live on in history for all time.
Yes. Learning something new every day. All right, Susan Punnett with the Family and Youth Initiative. And then Ernest Elliott with the National Center for Children and Families, Jasmine William Ashford from the National Center for Children and Families, and Sharika McCarthy from the National Center for Children and Families. And you may begin.
Good afternoon, Chairman Parker and
if you can really try to speak into the mic. Awesome.
good afternoon. My name is Susan Panett. I'm a District of Columbia resident and Executive Director of Family and Youth Initiative. For 15 years, DCFYI has been connecting teens who are in foster care with adults who make a commitment to staying in their lives. We believe that every person, and especially every youth who happens to be in foster care, deserves family, however they define that family. We're proud to have introduced many teens to the people who become their adoptive families and to have connected many other teens with adults who have remained in their lives through foster care and into adulthood. Often young people think of these adults as family, despite having no legal relationship. We are strong believers in adoption, especially for older youth, and will continue to ensure teens who want to be adopted have every opportunity to meet adults who could become their families. We also understand that many teens are not open to adoption, often because they don't trust the system to find them a new family, they don't trust adults enough to allow one to become their new parent, they're worried about losing services when their case closes, or they don't want their legal relationship with biological family to be severed by a termination of parental rights. What we have never heard a young person say is that they don't want the benefits that come from having a permanent family. A place to belong, people who will cheer you on, support you as you make life choices, help you figure things out, walk you down the aisle, be a grandparent to your children, and love on you always. The problem is not that youth don't want family, but that the processes designed to create new families for children in foster care are adult-driven, not child or youth-driven. SOUL is the first type of permanency that is both youth-designed and youth-driven. SOUL will allow youth to achieve permanency without having to choose between services and lasting relationships, and without having to choose between maintaining birth family connections and building connections with a new family. The District of Columbia can be the second jurisdiction in the country to enact this innovative approach to permanency that addresses the reasons many young people do not currently achieve permanency.